May I, my lords, take a minute, my lords? Yesterday, that matter, DDA tree felling matter, which came, my lords, for another member to be appointed, my lords, for the vacancy created by Mr. Ishwar Singh, who has gone to NGT.
Oh, that's it.
My lords wanted us to suggest some names. We have two names, my lords, with some write-up also we have. My lords can consider, my lords. It's really for my lords to decide. Two suggested names. Anything my lords can take out.
Do you have any idea what is the profile of the remaining two now left out members?
One is Mr. Pradeep Kishan, and the other person is Mr. Limaye. What is
Madhu Limaye.
not Madhu Limaye?
He's an IFS.
What is one is Indian Forest Service
Indian Forest Service.
and other?
Pradeep Kishan is an ecologist. He has written books and all that. In fact, Trees of Delhi, he is the author, my lords. He is the author of that book.
Madhu Limaye. Sunil Limaye.
Sunil Limaye.
Limaye is the judgment.
Both are outstanding person.
It appears to be, my lords. So, in fact, my friend had some knowledge about the work done by them.
Both are very good. Advantage of Mr. Sinha can be that he has worked at the ground
Yes.
in this very area
That's correct.
because he has been serving in Haryana cadre.
That's correct. That's correct. It is entirely my lord's decision.
Suggestions.
These are just
Out of the serving two members, one is
Yes.
already a ecologist.
that's correct.
So we nominate MD Sinha.
Yes, yes, your lordship.
इसमें क्या करना है? कल आया था ना? तो on the recommendations of the learned Micus, the learned Micus, Sri Guru Krishna Kumar Singh, advocate learned Micus has suggested two names. Ishwar Singh has gone to NGT,
Yes, my lords. Ishwar Singh.
has pointed out that the one of the member of the expert committee, Mr. Ishwar Singh, has joined as a member, National Green Tribunal. And as such, some new appointment in his place is required to be made. And as such, a new member of the expert committee is required to be nominated in his place. See, Kumar and Madam have suggested two names. Suggested some names, out of whom we deem it appropriate to nominate Sri MD Sinha, Indian Forest Service and retired, former Principal Secretary, Department of Heritage and Tourism, Government of Haryana, as one of the.
Very well. Just one other thing I wanted to point out, my lords. Really, as a follow, Suamoto initiated proceedings for greening of Delhi, my lords, and passed several orders, including appointing the Forest Research Institute as the agency with that expert committee, my lords, to oversee the entire exercise, including the budget, etc. Various directions have been passed. I was going to circulate a note, my lords, for my lords' consideration.
That matter.
No, that matter, my lords, is really coming out of 4677, so it's really before my lords.
Please tell us immediately you like this one.
That's correct. What I'll do is
This
this.
should have been along with this matter.
Actually, my lords, it was coming. It was heard with this matter. Then, my lords, the contempt got listed before another
But
bench.
date we have fixed. If you have the number, madam, you have,
I'll just share it with the.
so give the number.
Yes,
We will not wait for the next day. We
Yes.
will list this matter next week,
right.
just for a directions only.
Yes,
And then immediately now that you have told me, then I have something in my mind.
Right.
We'll try to do, and then we list along with that.
that's right, my lords. That's right. We'll, in fact, give the latest order, my lords, which has been passed in that.
Oblige.
You just give the number. We'll
Yes.
list it next.
Oblige.
And maybe that, maybe some relevance of this Delhi AQI,
That's correct. It will have a bearing, my lords. It will have a bearing.
some interconnectivity.
Absolutely.
What is,
Absolutely.
Monday. So Monday then give, then let this matter be also on Monday along with that.
Yes. The scope of that order proceeding is really two things, my lords. One is census of trees. The other is, my lords, greening. So greening
When we are
substantially will have a bearing
when we
on.
are fighting for a improvement of AQI,
Absolutely.
greens are
Naturally will be part of that.
one of the most viable and
Absolutely.
most effective long drawn solution.
Absolutely. Absolutely. We'll just give those details, Manoj. Deeply, Manoj.
Thank you.
Your Lordships, I'm seeking liberty to mention an application. Six,
Listening, we have stopped.
Manoj, let me try and persuade the court. Manoj, 6 presiding members of DRTs across the country.
Let it be done. File the application. We will. This mentioning part is not entertained. File some applications.
Manoj, we filed the
First you
application.
file mentioning, then some early hearing, then matter listed, then
Manoj, we filed the application. I'm
see
only
how the consumer of justice is being consumed.
Manoj, we filed the application, Manoj. I'm only saying it may be listed because they'll retire.
We'll list the MA. We'll see it. Item 1.
Please, my lords. My lords, here my lords have issued limited notice in respect of petitioner number 2 and 3 with quantum of sentence. So, my lords, it's listed today for directions. Otherwise, my lords have granted leave. So, I was, my lords, wondering how. They've already undergone, and accused number 1 has undergone his full sentence today of 10 years. The relevant part, my lords, that I would have been relying upon at the time of this matter was, if my lords will see page 5. Now, these two ladies.
What is listed today is main case.
My lords, it's shown for directions.
Direction. So these are where the sentence is undergone.
Lords, I will be praying if it can be done as sentence has undergone, they have undergone some sentence already. And if my lords will look at page 5, this is most absurd.
No, if you want, we can finish the matter by.
My lords may do it sentence has undergone for these two. And one of them is extremely sick now. She may not even be survive it also.
Any serious objection?
Well, as I've issued a limited notice, Melo, with
Well,
respective quantum.
we have to get rid of these matters now. Ultimately, occurrences of 1990.
Well, as I've gone through the
And my
facts, I'll
lord's
leave it to the
order-
court. I've gone through the facts, Melo, I'll leave it to the court.
My lords granted bail in 2016.
And in any
Today
case,
we
we
are
are not
quite 10 years
acquitting.
there
We are
also.
not acquitting.
Well, as the nature of the offense is serious. However, in the peculiar facts, I have also gone through it, Melo.
No,
I'll leave it to the court.
definitely. Offense is very serious. No doubt
Yes.
about it.
Therefore, Melo,
Therefore, there is no leniency.
yes.
It is only balancing that when you uphold the conviction, then on the question of sentencing when comes,
Yes.
then you can always consider some mitigating.
I mean, otherwise I must point out, Melo, what it's a case of concurrent conviction and 10 years. She has undergone around 1 year, 7 months. However, if I go through, if Mallets may go through the facts, Mallets, I'll leave it to them.
It's 2 years, I believe.
1 year, 7 months is what I've been
You
told.
would have some information, but I'm instructed about 2 years and with remission, it will be 4 years.
He was 15 years, 7 months, Mallets.
Because they will be
Extends
much
up
to
to
be
10.
said if we have to
Difficult.
argue, but I am willing if my lords.
There is a minimum say.
My lords, they won't be because here the conviction is 363 and 366. That is kidnapping.
No, Mallets, I must point out.
375 where she is concerned because that man.
I'm
has
clarifying that,
already
Mallets. I'm
undergone
clarifying. I'm saying conviction is under 366, which may extend to 10 years. It is not under 376 for them.
It's not for-
It's under 366,
The main
which can
accused
extend
has
up to 10
undergone.
years.
This
The main
woman
accused.
accused,
Yes.
so out of the, what is her name?
Anita Ben Mallets
Because one is.
and Manisha Ben.
And Manisha.
A5 and A6.
Ladies, they must be only for kidnap.
Their SLP is dismissed. Conviction is confirmed up till this honorable court.
And he is undergone and he is now released also, I believe.
What was the name of the main accused?
My lords, Rashmi,
Dilip Singh and Rashmi Bhai.
No, the male accused.
So A6, my lords, who is petitioner number 2 here, she is the wife of A2, the one who actually committed the rape.
You never know, she also might be a
being
victim.
accused in
My
this.
lords, considering the age of the girl and her,
Is Rashmi Himmatlal Dave. My lords have page 142, the trial court judgment. For a moment, my lords will find the list of accused there. Page 142, my lords. So, my lords, Rashmi Himmatlal Patel was the Dave.
Just a minute, the main accused
Hmm.
held guilty of 376 is Dilip Singh.
Only Rashmi is guilty of 376 and he's undergone the sentence, the full sentence. My lords, Dilip Singh,
he was charged for abduction, my lords,
he was
kidnapping
charged
and
for
abduction.
363,
Yes.
Yeah.
Okay. And Rashmi's SLP also dismissed.
also dismissed.
Babu Bhai,
He's
My lords,
dead, my
he's
lords.
not before he died.
But he died.
He died during the High Court while the matter was pending.
then
He
comes
died.
this Patel, Jasa Bhai,
4 is also dead, my lords.
eh?
3 and 4 are dead.
Appearing for 4.
Dead.
Yes.
Yeah, then appearing only for.
Now comes Anita Ben,
Yes.
My lords, it survives only for 5 and 6 today.
5 and 6.
Only
Okay.
5 and 6.
is in a five in the condition.
Now just come to the relevant page where they, what is the finding about these two?
Yes, my lords.
Yes.
That also ends with the statement. So, my lord, so far as 175 is 375 is concerned, they have not been convicted. 172, my lords, page 172. That's a trial court. My lord will find, and their conviction, my lords, is here in 172, last paragraph.
Well, the girl after kidnapping was kept in the house of A6, who is petitioner number 2. And then she was taken from one place to another. This is the primary allegation against these two. That
It's
the,
all right now, but don't highlight too much.
no, Melis, Melis had asked Melis what is the role ascribed to him. That's all. Melis.
This is not convenient. 1991. 16 years old victim had gone to fetch water at the public tap situated near the refinery post road in Vadodara. She did not return home for considerable time, which naturally prompted her father to lodge a complaint with Jawahar Nagar Police Station, District Baroda on 25th November 1991. Not father, mother. The complainant mother Thereafter, noticed light switched on in the house of accused number 1, which was closed on front side, and when she went on the back side and peeped into the house through a window, she noticed her daughter along with 3 persons. Next paragraph. Further investigation in the case led to say after the investigation, a charge sheet under section 363, 366, 376, 323, 506 and bracket 2 IPC was filed against 6 accused persons, including both the women appellants. The prosecution successfully established that accused number 2 was guilty of committing offence under section 376 IPC, whereas both the appellants, along with accused number 1, were guilty of offences under section 363 and 366 IPC. Accused number 4 and 5, 3 and 4 died during trial or after apprehension.
After trial, at least number 3 dies after trial while the matter is pending.
Subsequently passed away,
Yes. 3.
and hence it is not necessary to refer to the role attributed to them. Next paragraph. The tragic story is that the first appellant is wife of the main accused, against whom charges under section 376 IPC were proved. It is also a matter of record that concurrent conviction and consequential sentence awarded to the principal PL, principal accused, and some of his co-accused has already been upheld by this court in SLPC criminal number 761. Next paragraph. Regardless thereto, a leave was granted in the incident appeal in order to revisit the culpability of the appellants and proportionality of sentence. Both who have been released on bail.
Yes, I beg your pardon, ma'am.
Yes, ma'am.
Both have been released on bail.
Both were released on by bail by this court. My lords,
11,
which
16.
came order
Both of them were consequently
of 15/11/2016. Of 15/11/2016, my lords.
next paragraph. We have heard Lansing Council on behalf of the appellants, as well as Lund State Council at considerable length, and have scrutinized the evidence and record with their able assistance. Though the contention that first appellant would not have become party to the commission of rape by her own husband, though it seems attractive that it was nearly impossible for the first appellant to conspire with her husband to commit rape on the victim. We find that there is overwhelming evidence on the court to suggest that the occurrence took place on which that in the occurrence that the appellants have been attributed that the appellants have been accused of assisting the kidnapping of the victim
and her movement to various places after the incident. ठीक है, उसके बाद ये प्रिंसिपल एक्यूज्ड का फादर का हाउस में उसको
IPC is said to have been committed.
after the commission उसको secret कर दिया.
And was kept at the house of the principal accused after committing the offense under section 376 IPC. The evidence has been critically appreciated by the trial court as well as by the High Court. There is a concurrent finding of fact with respect to the role attributed to the appellants. In such circumstances, and knowing the scope of interference in a finding of fact based upon appreciation of evidence by this court in exercise of its powers under 136, 171. We are satisfied that no case to interfere with so far as conviction of the appellants is concerned, is made out. Next paragraph. We have also heard Lansing counsel for the parties in the quantum of sentence. The appellants, both the appellants are women, thus belonging to the poor strata of society. Whether they willingly participated in the occurrence or the dominance of the male members of the family force them to do so is a mystery. Is, or they forced to do so is a star question. Is a star question. Which many a times has to be answered, keeping in view the socio-economic conditions of the co-accused. There are no criminal incidents. Both have undergone actual sentence of nearly 2 years. Their conduct post grant of bail about 10 years back is also there is also not blameworthy. It seems to us that no effective cause of the administration of criminal justice system will be served by directing the appellants to undergo a remainder of the sentence at this juncture of their life. So consequently, keeping in view the peculiar facts and circumstances of this case, the fact that the appellants are women, that they belong to poorest section of the society, next that they are not the main accused, and there are multiple mitigating circumstances on record, we are inclined to reduce the sentence to the extent they have already undergone. We ordered accordingly. The appeal is allowed in part. The sentence awarded to the appellants by the trial court or the High Court, as confirmed by the High Court, is consequently reduced to the extent of the period they have already undergone. The bail bonds furnished by the appellants are accordingly discharged unless they are found involved in some other case.
Please put some grades. Sentence. My learned friend wants to clarify. I heard it, my lords have said sentences that are wrong.
Oh.
Please. As per the last order, my lords had asked me to appear before the authorities. I've duly appeared there.
Anyone appeal?
On payment of GST. GST नहीं दिया था इसी पे.
Well, it's appearing, my lords. My lords,
Yes, yes.
my lords, he had in fact appeared, my lords, and he had participated, my lords, and he has been asked to bring certain documents as well, my lords. My lords, I leave it to my lords.
All right, thank you. So, when State Council clearly submits that pursuant to order dated 13 February 2026, the petitioner has joined the investigation. He has been asked to produce some documents to which he has agreed to. Plan Council for the petitioner states that the petitioner will continue to cooperate with the ongoing investigation and will appear as and when required. That means so, the order dated 13 February 2026 accessible. Petitioner shall remain on the arrest bail. During the penalty question.
My lords, with the liberty that in case he doesn't cooperate, my lords, we may move the appropriate court, my lords.
It is already there, always there, legal. Requirements.
Deeply.
Grateful, my lords.
My lords, item 3, I'm seeking a passover. My lords, I appear for the state. Mr. Luthra is leading me. I'm seeking a passover, my lords.
Very important legal issue, my lords.
Yes, this is something very serious, my lords, not like the.
The connected matter, your lordships have, my lord, your lordship, this is similar issue, my lord, pending. Your lordships have.
My lords, there's no similarity.
But this is the order passed on the connected matter. Leave this matter and all the connected matter before a bench of 3 honorable judges. There is an order passed by this honorable court. Not here, here.
I'm for the
What is
victim.
the point? What is this matter?
But the
Let's-
matter is, perhaps, whether after the return of the charge sheet filed, whether petitioner is accused
Default bail.
entitled for default bail. That
And
issue.
At the time that the
My
default
lords.
bail was granted, my lords, the accused was a ruling party MLC. I am the deceased's mother. The police filed it on the 92nd day, right to default, and when a writ petition was pending in the High Court, and I'm the driver.
But he is on bail.
Let
madam. He is on bail. Occurrence was in 2022. My lords were pleased to grant bail, interim bail. 22 onward, he has been on bail. Not the investigation was completed recently, not 2-3 days before, final charge sheet was filed after further investigation.
He has been released on interim bail.
My lords,
Yes.
we will explain what has happened. This is something very, very serious and much more than meets the eye. The accused, there was some level of collusion. I will not go further than that. A charge sheet was filed. A charge sheet was returned, my
Who is the
lords.
accused? Who is this accused?
Accused is the petitioner.
He's a ruling
He is
party.
A1. He is an MLC.
That is that we understand. Who is, what is the background?
He is an MLC.
Of the then
The then ruling party continues to be the MLC now. He is an extremely influential person. My lords, I'll explain the sequence of facts. Although I am seeking for a passover, my lords.
And the murdered victim
My
was
lords.
his driver, my lords.
There was
Postmortem.
My lords, a charge sheet was filed.
Until now, cognizance has not been taken of the charge sheet. Trial has not started. It is leading to.
My lords,
To a miscarriage, my lords.
a charge sheet was filed within the stipulated period. He's saying stipulated period returned only for want of some FSL report. And default bail is granted. 3 years.
No, we understand. The prosecution was hobnobbing with him.
Now we have
They
recently.
deliberately do not file the charge sheet along with.
Now we have filed the supplementary charge sheet, which is extremely damning. My lords,
But
Mr.
with my friend's permission, though she's doing a better job than I am not.
They are
As always.
definitely.
As always.
And
As always. Lord.
particularly
Young
youngsters in
people
our
better
court,
always.
better job.
I'm the murdered victim's mother, my lords.
Lord, it's actually quite disturbing. I want
Problem
your
is-
lordship to see the injuries.
Problem is, now tell us. 2022, this court grants bail. What face we cancel the
My
bail?
Lord, I understand, but
Expedite-
consider one thing, Lord. I must tell your lordship 2 things. Matter comes up, Lord. Interim was
And
granted.
we have never been able to appreciate. Now I am surprised I am getting matters every day listed. In bail matter,
Can I make
we are granting interim bail, leave granted. A bail matter, what is there to grant the leave?
Good.
You dispose of him with one line order.
Can I just show your lordship one thing, Lord? I want your lordship to see, Lord, in the counter affidavit of the private party, not page 176. For a moment.
The victim's.
Victims counter.
Yes.
R2's counter.
R2's count. Preliminary counter.
And not,
What stage of the trial now?
It hasn't started.
not, I'll tell your lordship, one charge sheet was filed earlier, not finally after all that struggle. And I must tell you, and not then the second is now being filed, not because unfortunately, as your lordship said,
Look, you are great police also.
Lord, we had a problem, Lord, your lordship will understand, because in a case like this, Lord, to file a defective charge sheet, and on defect of what? FSL, and the court returned it, Lord, and there's the sheet where which the return has happened is quite disturbing. It goes up and back, up and back, up and back. And the Andhra Pradesh High Court had taken a view much earlier in 2009 that a charge sheet, even assuming it is returned for defects of a technical nature, the refiling with correct particulars relates back.
Mr. Luthra, his court in 1980, Satyanarayana Musadi, said if the charge sheet complies with 173(2), accompanying documents there or not there does not change the character of a charge sheet. Law
I
is very
understand, Lord.
clear.
Lord, the law is clear, so I'm not.
The thing is,
thing is on facts. He's been on bail from 2022. We'll keep this issue open and.
Lord, can I make a suggestion? Can I
Is
make a
there any
suggestion, Lord?
allegation from 24 till 26
Can I
misuse
can I
of
make a
property?
request? Can I make a request, Lord?
Earlier now you are blaming that he was politically affluent and this and that. What has happened after you came into
Lord,
power?
what happened was, Lord, we came to power change in 24, Lord. After that, this file was revived, Lord.
Mr. Luthra, 24 to 26, your police is filing second charge sheet only.
Yes.
What action have you taken against them?
Lord, we could only
We
do
want
that,
us
not
to
because
place
the
them in
matter
the
was
system.
pending here. Lord, matter was pending here.
In a murder case where a political person is involved, where you are making
Lord,
so
just
much
see the
even-
post-mortem, Lord. Yes. Lord, can I show your Lordship one document, Lord? 31 injuries.
Have you issued even a show cause notice? Forget about suspension of a police officer who have not completed investigation for all these long years. Please show us.
Lord, I must tell your Lordship, I
Because
put the,
everything you want to be
no,
blamed on
Lord,
courts.
no, Lord. I put this,
Because this is also
my
a
Lord,
very
my Lord,
good
may I just say this?
political,
May I just say this, Lord?
mastery in these
May I
days.
just say this, Lord? I put this question to the officers yesterday. Have you taken any action? He said the first task.
What authority a DGP has to continue if he cannot control as superintendent of police or the IO
First,
that
first
seek
task
his
was to take
explanation.
back the documents and get hold of the documents because the documents were.
First, you should initiate a disciplinary proceeding.
Yes, Lord. Lord, I put it to, Lord,
See what is
Don't have
I put it
documents
to
or
them,
don't have any material that which you are
My Lord,
fabricating
I have
report
put
against
it,
him.
may I make a suggestion, Lord? I put it to them, Lord, I'm given to, yesterday, Lord, this conversation happened and the officer had to get back because the investigating officer was only on call when I discovered this imbroglio.
Because look at the
Right now.
I understand,
Lord,
Lord, may I just say,
reality of the.
May I place one subsequent
Lord, can I
fact, my lords?
just, one second. Can I show you one document, Lord?
No, we will not see anything. We will.
My lords, as the victim's
Lord-
mother, I may be permitted to say something.
If
That
you are incapable, we can transfer this investigation to CBI today.
Today, the supplementary charge sheet has been filed, which is all the documents. I've got it, Lord, I'm carrying copies.
Lord-
Cognizance has not been taken.
My lords, cognizance has not been
Please
taken,
grant.
trial hasn't started. The
Kindly-
trial must be expedited to close within 6 months, so that will serve the interests of the victim and the
No,
accused.
not let
Just a
this,
minute, just a
not, may I just say this, not let the man be in custody at least till the major witnesses are examined, not otherwise in a 302 case. His wife not had got an order from the High Court because there was a notice given to her, that matter was pending.
Everything you want to settle inside the courtroom only. Outside courtroom, as if the state and its authorities have no duty. There you want to have a collision, you want to appeal someone, and here you want everything.
Lord, we can only plead with your Lordship. Lord, I must tell your Lordship, there was a gap. I understand. But Lord, today, I'll get that instruction is all I'm saying.
Police officer like this.
I'm sorry, Lord.
With a police officer like this, save the prosecution. Forget about his bail.
Lord, fortunately,
What
not there's
investigation
been a
you-
change of the officer. We changed the officer. There's a new, not young officers come in.
Poor man.
My son
Young
was
officers come
murdered,
in.
my lords. I'm the mother. The trial hasn't started. Charge sheet has not been taken cognizance of. He was a driver working for the ruling party MLC.
Leave granted. The appellant is stated to be a sitting member of Legislative Council in Andhra Pradesh, belonging to a political party now in opposition. He is accused in FIR number 195/2022 registered under section 302(201)34 IPC, section 311 SC/ST Act, police station Sarva Parvaram, EZ district. As per the conscious of the fact that any observation made by this court at this stage might cause prejudice to parties. We have no reason to doubt after reading the impugned orders that the police stroke investigating agency has been hobnobbing with the appellant accused. All efforts have been made to offer bail to him on platter, though the High Court did not grant it. Next paragraph. When the instant petition came up for hearing on 12th December 2022, this court granted leave and directed that the appellant be released on bail.
State didn't even.
यहाँ पे लिखा था ना ऊपर to offer on platter bail in default bail under section 167(2) CRPC 167(2) CRPC. उसमें वाले ना how are the High Court to grant the same, giving rise to these postings. उसके बाद ही आएगा फिर on so and so date and release the appellant on bail. He is thus enjoying the benefit of interim bail from last more than 2.5 years. Next, on a repeated query from Mr. Siddharth Luthra, Learned Senior Counsel for the state of Andhra Pradesh, informs that now a supplementary charge sheet has been filed. This again shows, this again shows laxity, if not complicity, of the state police in state police with the accused, exhibiting their grossest negligence in the matter of investigation of an heinous offense. Next paragraph. In order to strike balance between the right to liberty on one hand and fair trial to the victim of the crime and his family, we dispose of this appeal with the following directions. One, I request Honorable Chief Justice of Andhra Pradesh High Court to entrust the trial to a fairly senior judicial officer who shall take up it on weekly basis. Why? The issue regarding framing of charges must be decided before 14th March 2026. Next paragraph. After framing after the issue regarding framing of charges is resolved, the prosecution is directed to produce all the witnesses, to conclude its evidence as early as possible, but not later than 4 months from the first date. How many witnesses you have?
But may I say, Malad?
58.
58 witnesses, Malad, may I say, Malad?
What 58, Lord? First and second.
May I say one thing, Malad?
That is another way of.
87, Lord, 87. Total is 87.
Subject to.
A prosecution case, then you have a long list because you give
87.
long rope to
Lord, may I just say this?
to win over, to run away, to this and that.
Lord, the High Court was not just seen, Lord. There was not the High Court was seized of it. Not there is a, I'll just show Lordship, there were directions given by the trial court, Lord, for further investigation as late as not the
May I make one small
July of 25.
This is what exactly you want to entangle. Now, your intention is also not to bring the guilt home. Your intention is
Today,
this is a new trend that you keep person under trial, keep him inside and blame him. That's what.
Lord, I can show your Lordship the supplementary charge sheet. It is,
Next,
I would say,
next
fairly
number
comprehensive.
charges का लिखा था. Number 3 direction. Simultaneously, if any further investigation is required, the same shall also be completed within 2 months. By 31st March कर दो. By 31st March 2026. उसके बाद charges का कर दो. Charges will be framed by.
Shall be heard and decided. Heard and decided. Not otherwise they'll come back.
Shall be heard and decided.
But may I make one small submission, Malad?
The issue regarding charges shall be decided by 15th April.
Inquiry.
By 18th April 2026. Next paragraph. The prosecution shall be directed to produce the entire evidence within a period of
May,
4 months.
but may I say one thing, Malad? May I say one thing, subject, my lord, I appreciate.
The only choice you will cancel the bail.
I'm not
Put you inside.
Lord, I only saying, but I only bring to your lordship's notice. Even number 207 copies have not been furnished so far. Now, they have filed only charge sheet today. I don't think, my lord, that they will be in a position to give the same. So I only bring.
That is by on or before, say by 31st August 2026. Next, for the trial court shall grant a reasonable time to the appellant with defense evidence within a period of 2 months. Next paragraph, the trial must come to an end by 30th November, 2026. Next paragraph, we request the portfolio come administrative judge of the High Court to monitor the ongoing trial only for the limited purpose of compliance of the directions issued herein above.
Don't have, we can add,
Issued herein above.
they know it.
Next paragraph. The within evidence prosecution is only granted. Firstly, the eye witness or other vital witnesses shall be examined. Next paragraph. The continuation of bail of the appellant's continuation on bail shall entirely depend upon his conduct during pendency of these proceedings. If it is found that he has made any direct or indirect attempt to influence the witnesses or tamper with the prosecution evidence, the necessary consequences must follow. The necessary consequences must follow. Next paragraph. जहाँ पर आता है टाइम उसी में ऐड कर देना the with a view to facilitate the conclusion of trial in a time bound manner, the High Court is requested to spare the officer largely from other responsibilities, other matters, so that
25.
the current trial proceedings can be taken up at least once in a week. At least once in a week.
Lord, can I seek one indulgence? Just same, Lord. We moved, and I must say this, Your Lordship put to me, just same, Lord, the order. Not one thing, Lord, we moved for investigation because it was blocked, Lord. Thereafter, we got the order. Please see that. That's on my behest. Please just see, Lord, page 5.
Not to pass any interim order, staying the trial, and if any such issue arises, the party shall be at liberty to approach this court. Yes, now tell me.
Lord, just seem, Lord, the order I passed trial court, Lord, state moved the trial court asking for permission to do further investigation, and that was granted, Lord, now in July. Please see, Lord, page number 6, page number 5, Lord.
What should we do?
Lord, no, Lord. I'm saying, Your Lordship put to me that we were lackadaisical. We moved because, Lord, earlier the issue was something else, Lord. Lord,
That 3 months have also expired.
Lord, we filed it. Lord, my Lord, may I just say this, Lord, Your Lordship has passed an observation that we didn't do anything. Lord, we moved the trial court, got the permission.
Except hobnobbing.
Lord, we filed it within time now, within the 3 months, and we asked the trial court to give that order, Lord.
Complete
Milord,
collusion.
may-
Connivance.
Milords, may I make one
Lord,
request?
after,
Milords?
Lord, after the
delay to
administration has changed, Lord, things have been different.
Thank you very much. Thank you.
My Lord, the observations are rather harsh. After, Lord, then please record that we sought this, not otherwise I'll be failing in my duty.
That is, unless you really take them to the task.
Lord, I appreciate. My Lord,
There is a clear case of nexus of the power and the police.
my Lord, may I just request Your Lordship, Lord, one thing. Lord, we moved an application on 23rd of April. Just see for a moment, page 7, Lord. I'll leave it to Your Lordship.
No, we will not look into anything. Why should we look into it?
Lord, because we
are only
took
examining
steps, Lord. Lord, we took steps in April of 25, Lord, to get the further investigation reopened up. And then we got the order and we filed.
Go ahead.
Lord.
Now that you have completed.
It's filed, Lord. It's filed. Charge sheet was already filed within the time stipulated.
I think we will give a compliment. We are not going.
No, Lord. I'm saying it's not the compliment. It's not the qualification that I'm worried about. Your Lordship has passed an observation that even after change, Lord, there's been an issue.
Absolutely. That is what they are doing.
My Lord, may just, anyway, Lord, my Lord, may just record that we filed the supplementary charge sheet.
We have said so. We have filed so. We have said so.
And my lords have taken care to curtail any dilatory tactics by ensuring that there will be no stay of the trial and the trial.
All right, thank you. Thank you.
Time bound. My
Items.
lords.
Deeply obliged, but grateful.
Item 4, Malad, I appeal, Malad. Malad, out of 8 years, petition has already undergone 6 years, 4 months, Malad. Yes, Malad, he was released on bail. Malad.
Trial is still pending.
Malad, appeal is pending. Appeal is of 22, Malad, it's pending, Malad.
7 years for DG. Because minimum.
Hmm.
6 years already.
6 years already. 6 years, 5 months, Malad. Already undergone.
But that the appellant has already undergone 6 years of imprisonment out of total 8-year sentence.
To be precise, it's 6 years, 5 months he has already undergone.
Comma, the instant appeal is allowed. The impugned order dated 12th January 24 of the High Court is satisfied.
Modified. Modified. High Court is modified, upholding the conviction and reducing the sentence to certain.
Appeal is still pending.
Appeal.
Passed by this court is made absolute. Consequently, the appellant shall remain on bail. Consequently, the sentence of the appellant shall remain suspended and he shall continue on bail during the pendency of pending appeal before the High Court. It is clarified that we are not expressed any opinion on merits.
Very good. Match up.
Your Lords, I have deposited the amount and I produced the mobile phone today morning because I traced out only yesterday night.
So I need to take instruction as far as deposit is concerned.
I produced that mobile phone today morning.
So you asked him to deposit.
He's saying today morning.
I deposited
It was
the amount.
lost.
He is also playing all mischief.
First he said it is lost.
Lost.
He said that he traced out in Bangalore and yesterday he got it and today morning we deposited before the investigation officer.
Complying with earlier
Bangalore.
Only he has traced out yesterday, not with the IME number. He got it from Bangalore and he.
Has he ended or?
It's today morning he's saying I need to.
You don't know because obviously because in the morning he said.
Yes, ma'am.
You verify it, right?
Yes, ma'am.
And you just see that he has he given some fake item or is it?
That's the reason why.
Verify, otherwise will dismiss the petition.
Yes.
His conduct requires dismissal, but anyway, say it is claimed that the order dated 13 February 2026 has been complied with today morning. Now State Council seats are granted 1 week time to verify.
Yes.
Post the matter on so and so date.
I have deposited 30,000 also.
Let us see.
Your
Lordship, on the instruction, we wish to withdraw the SLP.
Withdraw all
Yes, sir.
non-counsel for the petition.
Yes, sir.
Permitted to withdraw this petition. This way.
May it please your lordships. Please, Minister.
So I appear for respondent number 2 in this matter, in which means I am seeking 2 weeks' time to file my counter affidavit.
Counter by not being prepared found. What was the matter before Justice Sundaresh bench?
My lord, this was justice. That was issuance of notice. My lord, these are 3 challenges to 3 separate bail orders. These are the 3 conspirators in the murder of my brother, the deceased. It was the second 2 SLPs, SLP 2 and 3. That is accused Rekha and Subhash. These were listed for notice before Justice Sundaresh.
What is the use of cancelling?
October, my lord. My lord, my only grievance as brother of the deceased is there are threefold reasons, my lord.
So the pre-trial detention will be punishment for them?
My lord, parity is given to the main accused.
Forget about parity. Rightly, wrongly, he is being on bail. There is no allegation of misuse. We are not going to.
My lord, there is a complaint. There is a complaint post bail.
Let that be inquired into. And if necessary, you
That
take.
if there is a misuse of concession of bail, for that you have to go to the High Court for cancellation.
My lord, my only consideration that I felt my lords would heed
We will
was
grant you, we can grant you liberty that in case there is any instance of misuse of concession of bail, we will be at liberty to approach the High Court for cancellation.
then my lords may grant me liberty to approach the.
Say, in the instant, as the instance specially petition is directed against order dated 17 December 2024. And so on. So there are, whereby the respondent accused have been granted regular bail. One of the ground taken is the alleged misuse of concession of bail. While we do not find any ground to interfere with, while we do not find any valid reason to interfere with the order granting bail to the accused, liberty is granted to the petitioner complainant to approach the High Court for cancellation of bail if there is a specific instance of misuse of concession of bail by the accused. So, with liberty of action.
Grateful, deeply obliged.
Your Lordship, I'm seeking a short passover in this matter. Item 8.
Not password, then we'll take up on some other date.
Please, Your Lordship.
You are on bail.
Some other day, Maharaj.
Yes, it's on
You
bail.
are on bail.
But this needs consideration, my lord.
Yes, yes, my lord. Putting it on another day.
That's all.
In due time.
This has become purely academic now. Lord, I may only point out, this honorable court, by way of an order, has permitted further investigation and recently even extended the time. So it's academic on both counts. He's now on bail.
We will examine this because
My lord knows, Maharaj, the section 44, Maharaj, your lordships have been
very well. I leave.
yes, obliged knows.
Mr. Jetmalani, we will take up this matter next week. Or?
the other one, my lord, that is 10. This is 8, that is 10.
ED.
This was
Mr. Jetmalan is.
That's item 10, Maharaj.
That cancellation
Your
of
matter
bail.
will take up.
Mine is 10
as my lord, please.
Against the bail.
against the bill.
Yes, that's challenging our bail, granted by a detailed judgment of section 46.
I'll point out how detailed.
Every aspect has been considered.
We will take up on some other day,
Yes, my lord.
not on a Friday.
Take it after holy.
We can take up after that.
Yes, that'd be better, Maharaj.
So 10 hours.
Obliged, my lord. Deeply.
So grateful. That's all right.
10 also.
Get time for this.
Well, your Lordship is keeping 10 also after the break. I'm over.
Please, my lords. Lords, in this, from me, the recovery is there of 5 kgs of ganja, which falls under intermediate quantity, my lords. And the prosecution.
Only 5 kg.
It falls under intermediate quantity, my lords. And the prosecution witness, who was the Caesar witness, also here.
Some regrets that your recovery is too small. Huh?
No, my lords, even the independent witness who has been examined, who happened to be the Caesar witness, he has turned hostile, my lords. He has not corroborated with the story of the prosecution, my lords. And 3 persons on a bike carrying 30 kg of ganja and 4 bags.
Motorcycle, why not? Between the two sitting, 30 kg, what is the 30 kg?
3 on a bike, my lords.
Bike?
And 4 backpacks.
You are talking as if we are coming from some different part of the world.
My lord, from my possessions, my lord, it is
You are talking bicycle or motorcycle?
motorcycle. My lord. It is,
So you can carry it to 30, 40, 100 kg even on bicycle in India.
3 persons were also sitting on that bike, my
It all depends upon your power of pedaling while sitting behind.
yes, my lord. The witness, which is the Caesar witness, he has turned hostile, my lords.
That's a different issue. Argue on merit, but 5 kg and 30 kg.
There is a violation of section 105 also, which says
How much time you have spent?
11 months. Till today, my lords, 11 months, my lord.
It's all over.
My lords, 12 witnesses
out of 11 have been examined.
Out of 11 has been examined.
11
Yes,
have
my
been
lord.
examined, my lords.
May I correct one thing? It is an incorrect statement. These are the order sheets of the learned trial court. Out of 12, only 6 has been examined, my lords. These are the order sheets of the learned trial court. And the learned additional superintendent of police is making this deposition before this honorable court that out of 12, 11 has been examined. Kindly have that order sheets, my lords. 6 have been examined and 6 are left, my lords. And they are not turning up for the examination, my lord. There is the order sheet.
Antecedents, because he is operating.
We have filed a counter, my lords. There are 4 other antecedents.
5.
Though with not of NDPS, but they are. And he is resident of state of Rajasthan.
Again, my lords, at page number 16, my lords may kindly have at page number 15 and 16 of their counter affidavit, what they have stated. Crime number so-and-so, offense so-and-so. They have not even mentioned the PS, police station. They have not mentioned the date. In each and every one of the FIR.
You are aware about your.
No, my lord, there is
How
no
many
criminal,
gold medals you have?
criminal antecedent, my lord. Because of this fact, their trial court order is there. While my bail was dismissed, this observation has not been recorded. In the High Court's order, also in the impugn order, this fact has not been recorded because there are no such cases. One FIR is of 2029, my lords. Kindly have serial number.
Earlier you were in Excise Act, now you have come into NDPS Act.
Not a single FIR against me, my lord.
You are upgrading yourself.
If in that case,
Pressure has also increased. Earlier you were confined to Rajasthan and Haryana. Now we have gone up to Chhattisgarh.
my lord, the state of Rajasthan has issued me a certificate, character certificate, where they have stated.
Rightly so.
So, my lord, these FIRs may be brought on record. I am stating that if these FIRs are against.
No, certificate for the original manufacturing.
No, my lord, character certificate that I don't bear any criminal antecedent. They have stated, and kindly see these FIRs. Even the PS is not mentioned. Which police station is this? Not even mentioned the PS, not even date is mentioned. One is of 2029, serial number 4, my lord, crime number 5 of 2029, my lord. Right now we are in 2026.
The appellant is an accused in FIR number 101/2025, registered under section 20 in bracket small b of the NDPS Act at police station Jagdalpur, Bastar district, Chhattisgarh. The appellant is a resident of Rajasthan. The prosecution case is that on 21st March 2025, the police received an information that 3 persons carrying approximately 4 kilograms of ganja were traveling on a red motorbike in the area. They were intercepted. On such 30.84 kilograms of ganja in 6 packets of approximately 5 kilograms each are stated to have been recovered from them. This is their bags, mobile phones, and red bike were also seized by the police. And all of them, including the appellant, were arrested at the spot. Next paragraph. The appellant's main contention appears to be that only one packet of 5.124 kilogram is said to have been recovered from him, which is below the commercial quantity. Next paragraph. The High Court, by the impugned order dated 27 June 25, has declined bail to him. Next paragraph. We have heard the request for the party. Record to use. While it is not expedient to express any opinion as to whether the appellant, being one of the pillion rider, would be deemed to be in conscious possession of the entire quantity recovered from them, or such quantity shall be confined to 5.124 kilogram only. As such an issue shall be decided by the trial court in due course of time. While he is strict at the outset, we are not inclined to explain. We do not deem it expedient. Can say, however, take into consideration the period spent by the appellant in custody and the fact that conclusion of trial may still take some time. Command instant appeal is allowed to include order of the High Court is satisfied, and the appellant is directed to be released on bail, subject to his furnishing bail bond to satisfaction of the trial court. The appellant shall furnish adequate security to ensure that he remains present in court on every date of hearing unless granted exemption. Order recorded. Let him now go on bail because after trial court will come under pressure.
My lord.
To decide trial in 1 month, 2 months.
Oblige, my lords.
My lords, this is a matter under the Foreigners Tribunals Act. In this case, my lords, even though there is evidence from my mother's side, my mother, my maternal uncle, my grandfather, the tribunal only considers my father's inapplicability. Here, my father has passed away. He had a mental health issue. He passes away. The Gaumura documents my birth, documents my lineage. The Foreigners Tribunal does not consider that either, my lords. May I just take you to my written statement, my lords, which was filed before the tribunal, annexure P11, my lords. And then I'll take you to the Jamabandi also, my lords. P11, page 80, my lords. My lords have this?
Yes.
Yes, may I read, my lords? That the second party father, Moqsed Ali's name has recorded in the NRC of the village of Barbuza in the selected district of Barpeta, Assam. And then second party's father shifted to Kajhar village in the district of Barpeta, Assam. It is stated that the second party's father has expired in the year of 73. The second party's mother came back along with the second party's brother, so-and-so, to her maternal grandfather, late Kalimuddin's house at so-and-so village in the district of Barpeta, Assam, and second party's mother gave up all relations with second party's father. Para 6, that second party's father had a mental health disorder, so his name was not recorded in the voter list of 1966 and 70. And my lords may now see, my lords, the annexures that we have attached, which show, my lords, annexure P1, page 33. My lords, we prepared a chart for you, which shows the maternal grandmother in 1966, 1970, the mother, 1985, annexure P4, 1989, annexure P5. Maternal uncle right through, my lords, all the years. We've just prepared a chart for you. The issue here is, my lords, the Foreigners Tribunal.
No. You please connect yourself with any of the documents. What was your father's name, first of all?
My lords.
My mental derangement.
Moksha. He My father dies, my lord, of cholera while my mother is pregnant with me. Then my mother goes back to her maternal home. The issue with the Foreigners Tribunal order, my lords, and this is a common issue, is they don't consider the female lineage, which is all my relatives from my mother's side.
No, they may consider not. You please establish your link. That how
Yes.
are you?
May I just take you, my lords, to the first annexure, P1, my lords. May I just trouble my lords with that? P1, my lords. This is the certified copy of electoral roll of my maternal grandmother. That's the table we are handed over, my lords, explaining all the annexures. My lords has this.
Yes.
So each of the annexures, my lords, we have attached one piece of identification of the maternal lineage. So P1 is my maternal grandmother. This is a certified copy of electoral roll from 1966. Your lordship sees this, my lords. 1966, it says the following details are hereby confirmed as per the electoral roll, and this is my maternal grandmother. Now, if I may take you to P3, this is similar certified.
No, on what basis you establish that she is your maternal grandmother? That is the point.
She is shown as the wife of my grandfather, my lords, page 34.
Well, how you establish that he was so and so was your grandfather?
The Jama Bandi, my lords. The Jama Bandi is annexed as, my lords. Please see the Jama Bandi, my lords. A12. P12, my lords. The Jama Bandi, my lords, knows, my lords, in villages, the Jama Bandi documents entire lineages of families, including births and deaths. Please see the Jama Bandi.
They have nothing to do with birth and death, but
my lords, please.
only a revenue record.
The birth is recorded, my lord. Jama Bandi, annexure P12, page 97, where my mother and myself are both recorded. Bottom of the page, my lords, 96, and then 97, top of the page. This is the Jama Bandi. Your lordship has this, my lords. May I read, my lords? Yes. Bottom of the page 96. The circle officer vide order dated 11/12/2015 in mutation case number so-and-so. The name of Rija Khatun has been substituted by virtue of inheritance to Rezak Talukdar, mother Rija Khatun.
This mutation is changed in 2015. What was the earlier mutation?
May I just take you to page 94? Her father's name is given here, my mother's father. So my name is on 97. Name, father's name, address to Pattadar, 94, my lords.
Yes.
Sri Nurul Islam, father Kalimuddin. This is my mother's father. My mother's father, my maternal grandfather. And then my mother's brother.
So even this will not help you because this is again 1982 settlement, the entry. The cutoff date is 1971, March 1971. So you have to show that this maternal great grandfather was recorded as owner of the property. First, you have to show that some XYZ person is recorded as owner of the property prior to the cutoff date of March 71. Then you have to establish your pedigree with him, that how your relationship is established.
So my great grandmother is there in 60s.
Because this is also an order of collector of assistant settlement officer of 82.
My lords, the Jama Bandi speaks to the Gaumbura, which is annexure, my lords, P10.
Unfortunately, there is a misnomer of the name Jama Bandi. This appears to be in the consolidation proceedings. This appears to be a survey conducted for the purpose of consolidation.
Yes, my lord.
There is a difference between Jama Bandi is a record of rights in the revenue record depicting the ownership rights of the person.
Yes, my lord.
No difficulty, presumption of truth is there, rebuttable. But the cutoff date is of 71. So one has to be recorded as the owner, co-owner, joint owner.
P1 and P2 are prior to 71.
P1 and P2 are not Jama Bandi.
No, my lords. P2 is a revenue receipt. May I just take you to that and then I'll take you to the Gaumbura. P2 is a revenue receipt from my father's side and then I'll take you to the Jama Bandi, my lords. The Gaumbura, which is P10. Which documents, my lords, we are trying to establish the family lineage here. The problem here is that in poorer sections, when there is death and the mother goes back, it is particularly difficult. The FT should have considered some of the mother's lineage. Please see. P2, my lords. P2, your lordship has this, page 37. Please see.
Unfortunately, P4 also doesn't help you. This is a voter electoral roll of 1985. Yes. Again, irrelevant.
P2 has my father, my lord. Subject name, Moqshad Ali, son of Alhamdulillah.
1968.
This is 1968. Now, if I may take you to P10, This is the Gambura certificate, which names me Joynal Talukdar, son of late Moksed mother, Regina Khatun. So it names me, names my mother.
P2, where is the P2 name of your father?
My lords, P2, the name of the father, right on top of the page, my lords. Page 37, entry 1.
P2 is a landowner is some Bekunt Chandra Goswami.
Yes, resident of, subject name Moksad Ali. I was a tenant. This is,
Dr. Menka, how can this document be treated as a document of your residence?
then may I take you to P10, my lords, which is the Gambura.
But you can't be.
Let's take a Gambura. The Lordship may consider calling for the record before the tribunal, my lords. May I then take you?
Course of decided, you please show us something material.
Yes, may I just take you to annexure P10, page 78?
Absolutely no
This is
connection.
Gambura, my lords. May I just take you there? Annexure P10, page 78. Your lordship has this. My lords all have this.
78.
Yes, page 78. The certificate is issued that Mr. Joynal Talukdar, that's the
Who has
petition.
signed this certificate? Who has issued?
My lords, the Nurul Islam, the village headman, my lords. It's typical, my lords.
Under which law? Under which law the village head can issue this certificate?
My lords, the land revenue regulations, my lords, specific to Assam permit this.
Please show us the provision. Please show under which provision this certificate can be issued. Though this certificate also does not help you. Voter list of 1997 mentioned.
It documents my mother. Yes, and Supreme Court Justice Nariman recognizes the legal validity of this.
No, we are not, we will see later on who has recognized and how it is recognized. First show under which provision of law it is that authority is competent to issue this certificate.
That's it. Then
My lords, could I, if you could pass it over by a couple of items, I'll bring the hard copy of the.
Take up next week, you examine, you have first keep in mind the cut-off date of 71.
Ji, my lords.
Keeping that date in mind, see how you can correlate the documents. You have to have a sequence of chain of documents to establish that you are able to cross the cut-off date.
I'll do that, my lords. And I'll also bring your lordship's judgment, my lords, which recognizes the legal validity and the place of a Gambura and the context of revenue records.
Gambura we have no doubt. The problem is the Gambura has not been examined as a witness.
A witness.
Without that, a document executed by a person or issued by a person will not be admissible evidence. That is your problem.
And see the contents.
Gambura would definitely be a relevant document for consideration.
And this certificate says only what?
Examine the Gambura.
This certificate says that the above named person.
I follow. I'll
above named person was included in the 1997 voter list. That is not going to again help you.
What my lords, the Chief Justice is saying. I will strive next week, my lords, to convince your lordships. Get that Assam right. Run a case with it. I'm grateful for my lord's patience. Next week, my lords, I'll. Yes. I follow. I follow. Yes, my lords, I follow. I'll strive to do that next week, my lords. Yes. Mother's now died. Mother's not. Not alive. She's dead. She's not alive, my lords. Thank you, my lords, for patient hearing. I'm grateful.
Wait, please, Your Lordship. Your Lordships, the present specially petition arises out of a public interest litigation matter regarding an environmental matter concerning enforcement of statutory prohibition on PVC flex and plastic coated advertisement materials in the state of Kerala. My lords, the High Court had disposed of the writ petition by recording the state's assertion without issuing any enforcing or supervisory directions, despite continuous violations are being continued. My lords.
Notification को
My lords.
Very well prepared, you understand the law very well.
Yes.
The timing of this kind of litigation come now that your own case in Kerala elections are coming, restrain the state from doing this, restrain it from doing. How many states we will keep on restraining?
My lords.
The problem is this one, that and people start fighting political battles also in this court, whether it is Kerala, whether it is A state or B state or D state. Now it's all prayers are only to embarrass the state government. That you create some difficult situations for them. We issue direction, it becomes difficult for them to.
My lords, other states like Bombay are also having such laws, my lords. Already government orders are being passed by the state government, banning the PVC materials completely.
Your government already passed the order. Your government has assured the High Court that they will implement the order. There's a little hitch here because the validity of those orders are challenged by the Association of Flex Holders.
Yes, my lord.
So the bench has said that you implead yourself in that writ petition, and that will be a comprehensive list on which you can canvass your case of validity and enforcement, whereas the other side can canvass its case that it is invalid and ought to be quashed.
But my lords, as a respondent, we will not be able to ask for any positive relief, no, my lords.
You don't have counterclaims.
Then, my lords, at least your lordships may kindly pass an order till the decision comes out in that matter, in the connected matter.
You people want to create some impediment in the own, whatever the election campaign will be there. See, we are not there. Please see our role to play. We are unless there is some imperative interventions required in a matter.
My lords, I have handed over photographs.
High Court is conscious of this fact. They have issued some directions. If the directions are not complied with, the High Court will take care of that. You should continue to fight your issue before the High Court. Make sure that the directions already there, the regime already there, ban already there. All those are implemented. Your problem is of execution, implementation, not of the laws.
Yes, my lord.
For that, High Court is the most suited platform.
Then I might, your lordship may kindly allow me to file a review petition before the High Court.
There is no need of review petition. You just approach the High Court that this is the notification already issued. You have disposed of the matter. But despite these directions or orders in the past, this is how it's happening in the state. The High Court will take the remedial measures.
Your lordship may kindly at least pass a clarificatory order.
We will grant you liberty to approach the High Court.
Approach the High Court. Yes, my lords.
We have heard one counsel for the petitioner. We find that the High Court of Kerala has already dealt with the issue. If any further directions, if there is any need of further judicial intervention or the need to issue directions, the High Court is the most suited platform to address such issues. So, with liberty to the petitioner to approach the High Court, we are not inclined to entertain this special issues.
Grateful, my lords, highly.
Please, my lords. Was aggrieved by the order of the Uttarakhand High Court enabling the government to use land sealing land for the purposes of government construction without taking note of the fact that the division bench of the Honorable Uttarakhand High Court
The
has
Uttarakhand
banned.
Division Bench does not consider Section 25.
But the
Section 25 gives quite a elbow space for the High Court, for the state to make change of use of land.
I bow down, my lords, but these circulars, if you're
And
not.
these are public utility activities. How can you, madam, stand in the way?
It's not some for
It's
commercial
not
gain or
private clubs
private
being set
entities are
up or
giving.
something.
Lordship may see.
Constructing government offices
Yes.
is a great service to the society at large.
Milords,
Public at large.
there is very limited agricultural land and the government circular itself, Lordship may just have an extra P2, page 33, apart from the division bench.
There's a general principle that agrarian land should be given to landless peasants.
Yes, ma'am.
Then only to be used. But see, if all these rules, policies can't override the parent statute.
Milords, the
And
parent.
Section 25 is very clear
Milords,
that the government can settle, instead of settling land for agricultural purposes, permit permanently any land for purposes which fall within public purpose under the land acquisition.
Milords, the second ground,
And what are the purposes? One is housing of government servants and a de-addiction center.
Lordship.
Both are equally important.
Very vital for the society.
Milords, may kindly appreciate that the factual matrix of this case was also not appreciated by the High Court in this order. Lordship may directly have an extra P19.
So he's an intermeddler. God knows what is his agenda is going in the name of public interest. What kind of public interest he is watching?
Lordship may kindly appreciate it wasn't appreciated.
If today the state acquire the land, if today state acquire the land, spend use public expenditure, and then provide these basic amenities. These are not even facilities. These are the fundamental amenities which a area should have been provided.
Kindly appreciate there is a distinction between acquired land and sealing land because
Yes.
the objective of the Land Sealing Act is to promote agriculture and to give landless laborer. Whereas the Land Acquisition Act has a different purpose. But
Absolutely. Landowners will come. Let the landowners claim compensation or whatever right they have. Who is he unnecessarily talking about?
I'm a resident of that area. The second, my lords, mischief of the government, which was highlighted, which has come to light now. If your lordship would have an extra P19, it's a very serious thing that 39 SC/ST persons were given this land. And by me,
What the how the governments are functioning.
if your lordship would just have that one document, my lords, be perturbed by what the state of Uttarakhand has done to grab this land, my lords. An extra P19, my lords, it's a 2008 document written by the Tehsildar to the DM. And I will show that, my lords, in the counter affidavit and another petition, they have admitted that this is not surplus land. It has been allocated and is in possession of SC/ST persons. And now, my lords, they are just evicting them as encroachers, saying that our file is lost. Lordship may kindly have an extra P land.
No, we are not concerned. We will not go into this kind of.
These
are all political stunts. That's all.
No, there's no political.
We don't appreciate judicial time of the courts.
Lordship may kindly
look. Most privileged PIL.
My lords, this is a state document, my lords. This is agricultural land which is being snatched away from landless laborers.
Are having some political agenda. Dismissed.
My lords, may kindly hear me.
Very much. Thank you.
Lordship, kindly hear me. Lordship, may kindly
We will not.
P19. Without hearing me, I can't be thrown out of court. Lordship may throw me out of court, but after giving me a hearing.
Lordship, we know that what kind of agenda.
This is allocated land.
Yes.
Lordship may give me the liberty to bring these documents to the attention of the High Court.
Wherever you want to go, you can go. You can withdraw and wherever you want to go. We know that what kind of agenda people have.
Because this is a disposed of matter. I may be permitted to withdraw. This is land allocated.
You can withdraw and go there.
But Lordship,
say as far as the mail, write down.
Look, I'm showing a state document.
Say so far as the issue pleaded before the High Court which has been adjudicated by the impugned judgment dated 4 July 2025, comma, is the perfect view taken by the High Court, warranting no interference by this court. The petitioner appears to be an intermeddler who has been rightly ousted by the High Court.
Withdraw, I will file.
So, however, faced with this, comma, the petitioner relies upon some new document, annexure P19, which was not the subject matter of judicial consideration, which was not subject matter of consideration before the High Court in the PIL filed by the petitioner. As regard to the validity of that order, comma, we do not express any opinion, comma, full stop, the petitioner or any other public spirited person shall be at the petitioner or the affected person shall be at liberty to have recourse in law, to have their recourse in accordance with law.
Highly obliged, my lords, highly fair, grateful, man.
Yes, item 15.
My lord, senior advocate Siu sir is leading us on this matter. I'm taking a short pass over.
What do you want?
Item 15. We are for the
You
petition.
want a pass over or date?
Short pass over.
No.
Fine.
Well, this is a petition under section 11(6). Since it's an international arbitration, page 41 is the clause.
Notice, issue notice. Well, how are you going to serve them?
Well,
Uganda, they don't have Indian address here. Anyway, it is your edict. Issue notice returnable and so on.
I'm so obliged.
Lords, this matter arises from the Foreigner Tribunal's order. I'll straightaway take my lords to the lineage documents. The 1966 voter list is at page 36, my lord. My father, Karam Ali, is listed at 682. My mother, Kulsun Nessa, at 683. Likewise, in the voter list of 1970, my lord, that's on page 37. They are listed. In the voter list of 1970, my lord, they're listed at 825 and 826. This is at page 37, my lord.
Exhibit A and Exhibit B.
Where is Exhibit A?
Exhibit A to the BFT case, my lord.
Exhibit A before the tribunal. Have you attached it now document with us, before us? All right, where is the 1966 document? 1966 voter list of your grandfather, father.
It's at page 36, my lord.
36.
show us the connection that your father's name is appearing in 1966, 1970, and in your name is appearing as the son of so-and-so in the 1997 voter list.
At page 36, the 1966 voter list,
Yes.
my lord. My father's name is at serial 682, Karam Ali.
What is the name of your father?
Karam Ali, my lord.
Karan.
And mother's name, Kulsan Nessa.
Just a minute, just a minute. This page 36 is the voter list.
Correct, my lord, of 1966.
So how old is your father? He is 50 years old in 1966.
My lord, there is some discrepancy in the age.
That is the whole Here it is Karan Ali. Now you are producing a certificate of 1964 born Karam Ali at 35A.
My lord, that is a minor discrepancy.
How it is minor discrepancy? Age net. How old was your father in 1966?
My lord, that does not fall from the record what exactly his date was. His date of birth was.
70 years old. The 70 document.
May I proceed, my lord? Then 1989 voter list is at page 38.
I do not, sir. These are not the grounds on which tribunal has gone. Reason with the
At serial 850, my lord. My lords, this is thereafter certified by the Gaon Bura at page 31A of Kachumara village, where I resided initially, and my father was listed as a voter. And again at P2, my lord, 32A, this Gaon Bura certificate of the Gaon Bura of Mondera village. My lord, and the link and the lineage is also shown by the voter ID card, my lord, at 33A.
Certificate is authorized to be issued. Rest of all documents are contradictory.
My lord, the voter list, there is minor discrepancy in the name and age, my lord. Certainly,
If the name is also incorrect, age is also incorrect, and you say minor discrepancy in the voter list.
But then thereafter, my lord, it is certified by the Gaon Bura that.
Therefore, you are heavily relying upon the certification only. Under which provision of law the certificate can be issued? Please show us.
My lord, the precise provision I'll have to address, but my lords, in Rahim Ali, my lords, this.
See, your certificates of the way your father's name is completely different. The age is, with the passage of time, age is being reduced. In 1966, is 50 years. After 10 years, it's on 40 years.
My lords, administrative error, typographical errors.
Typographical error. You have to seek clarification, and somebody should have been brought a witness box to say that this age is incorrectly recorded. And ultimately, what happens? When the proceedings are starting, you are obtaining a serpent certificate. Serpent doesn't come in the witness book. Serpent has not seen your father in that age.
The Gaon Bura has been examined. I may take
You show us the law certificate. You keep on the same day to Dr. Menka's case. Show us that under the law, the certificate could be issued.
Very well, my lord. I'm grateful.
In 18, I am appearing in 18.2. Out of these 18 officers who had been compulsorily retired, prematurely retired, one officer's writ your lordship had been pleased to, SLP was rejected by your lordships. But the service record is different in each case. In fact, let me tell your lordships, 18.2 is a matter. 18 matters were put up before the court on 17 September, on the day when they were heard. Out of 18, 17 judgment was announced on the same day. In my case, because the facts were quite different, this was the only one which was kept and reserved. And later on, however, the learned judge has taken the same view. Your lordship may come to page 540, what I want to show. Just have 540.
Mr.
Well, Lord, actually, this man is what happened.
I could find that none of them deserve. Why should we?
I'll tell your lordship the point in this case. His record is good. There was a vigilance complaint which was put up before the three-judge committee, which said as follows: the learned judge consumes liquor in his chamber during working hours and misbehaves with the advocates. Learned judge does not sit on the dais.
When you are examining this kind of misconduct, you have to draw difference between Punjab and Gujarat.
No. So I'm just responding. That's correct. Now this later on it transpires. This complaint was not mine at all. It is of somebody else. And in fact, this man, my lord, he says he's a teetotaler. He has never touched a drop in his whole life up to now. And he says it's ironical this complaint is made against. Just have 2 pages, please. I have nothing more to say. On my file, please see page 540 and then see the RTI reply at 542. Therefore, it is fine. Now, I say, my lord, please see page 5. Therefore, my case was, in fact, even when those 18 were argued, was kept separate. If your lordship will see all other cases, judgment is announced the same day.
No,
Mine, it is on
which page you are referring to?
540.
For your satisfaction, 540.
This is the record, volume 2.
540 is something else.
18.2, my lord, Jayesh Kumar Krishan Kant Acharya versus Honorable High Court of Gujarat.
That's a different one.
Yes, 18.2. Volume 2.
Where are your ACRs?
Yes, it's all there. That is what the High Court produced. That is what was placed before the committee at page 540. It runs into 2 pages. If your lordship will see those 2 pages. Your lordship has got it. 540, my lord is. Shall I read the ACRs first? 2003 grading is good. 2008 it says disposal assessed as poor for the quarter ending June and September. Grading is good. 2005 grading is good. 2006 grading is good. 2007, this is how they have put it up, my lord. But at the bottom it says good, outstanding. 2008 grade outstanding. 2009 good, reasonably good. 10 grading good. 11 good. 12 they have said something, then in the end grading good, reasonably good. 13 they have said knowledge of law, etc. Grading reasonably good. 14 good, very good. Now these are my ACRs. Now see the next column. Vigilance complaint VC1 of 651 of 14. I have just read it. In fact, I can read it again. Learned judge consumes liquor in his chamber during working hours, misbehave with advocate. Learned judge does not sit on dais, and so all witnesses return from the court. Status, order to be filed. Now just see before I go to the RTI, just see my disposal. Now just average grade means 100% disposal. I'll show that. Good means 100 to 125% disposal. And just average means 100% norms. So all my norms are met. I am meeting 100% norms or 125. These are divided into 3 5-year batches.
No, but how 542 help you?
Just see 542. It says in reply to your application, it is stated that application VC contained allegations against Shri V.S. Dave, the then principal judge, and other judges made by an advocate.
So the complaint that was filed was against one Dave, not against you.
Correct. That's the whole point. It's the same VC 651. Now please see this page 540. Vigilance complaint number is 651 of 14. This is not, my lord, he's a teetotaler. He says, I have been, this is a double whammy for me. I have been retired and then given this certificate of drinking. I have never touched a drop in my whole life. The officer, this is his case. He says, I go to the temple, I don't have food before I visit the temple every morning, and this allegation is being made against me.
That is his personal life. We have nothing
Yes,
to do.
but my lord, I say this.
Gujarat most rarely anybody. Otherwise, people are they follow prohibition. They don't drink.
So who knows what would have happened if this was missing from this column 3 was gone. That is why the learned judge kept my case back, the division bench. And ultimately this is decided, and then ultimately the bench is pursued.
Page 539. 539.
Yes, my lord.
Poor in month.
Assessment of judicial work this is.
Most of the time you are poor.
No, my lord.
Inadequate, just adequate.
2001, my lord. Assessment of judicial work from 2001 in March, June, September. They say poor. This is divided for March poor, September good.
539 is from 2000 to 2016. It's for long 15 years. 16.
Yes, yes.
And see the column.
Yes.
2000 you are not assessed. Next is poor for 1 month good, other is adequate. Then inadequate, poor, not assessed good. Just adequate, poor.
This is disposal. Just see now the definition of poor, good and all. This is disposal. This is not record.
That's why we are only wanting to point out.
Yes, no, but see the definition.
Whether you took drink or not, that may not be an issue which we will go into seriously. That particularly when no inquiry is held and no complaint is found to be there, that issue we can overlook. What we are concerned is that compulsory retirement is normally of the dead wood. You just want to chop off those who don't work.
So please read page 239 with 145. Page 145. Just see 145, where these expressions are defined. These are disposal. These are disposal expression.
We are also concerned about the performance.
Yes. Please see that. What is the definition of poor? Less than 75% of norm. Inadequate between 75 and 90. Just 145. Volume 1, page 145.
Yes.
Assessment is also wrong, sir, because it says not assessed.
Not for 2001. That is for later year. If your lordship will see page 145, it says in evaluating the work of a judicial officer, in giving remarks of disposal, the following standard shall be applied.
Well, say 2015 first.
My lord, he was 53 when he was retired. And my lord, one other very important fact is that 1 year prior, he was promoted in December 14 as additional district judge, ADJ. And in 16 early, he is being retired within a year. This is, my lord, a very hard. That is the only reason why I am pointing this case out to your lordship.
Now he must have been having blessing this guy, good practice or good.
My lord, he is 61. My lord, what? He is 61. All that he will get, he has crossed the age of 60 years. All that he will get today, in the event I am able to persuade your lordship, is 8 increments in his pension.
We have just pointed out to you the performance page 530.
Lord, it is actually 2002 says good. Inadequate. Inadequate means 91 to 99% norms.
So the benchmark for the performance is that if you want to be an outstanding officer, you must perform 300% of the target, minimum target. So that's the way that it's not that the officer is taken by surprise. Everybody knows that if I am only performing below 100%, then I am not even adequate. I am below adequate. That is a uniform guideline for everyone. So before he started performing, he knew that what he is supposed to achieve for a good report.
Yes, there your lordship is right. That is there.
And we are not on any other issue, but for this 539.
Well, just kindly see from 2001, these remarks also are not borne out from the record. Just see P1 first. P1. This is 2003.
Yes, 2003.
Where is it? Where are you reading page?
It's 360.
हाँ. 1 तो poor है.
Not assessed. Then 367 it says not assessed. It was wrongly 367 not assessed.
June
think 12 is also not. 12 is also not.
It was also very, they were quite conscious of this fact that they are prematurely retiring. So first the matter was referred to a three-judge committee.
Correct.
Three-judge committee considered everything. And based upon those recommendations have been approved by the full court. In a case where there is, yes, of course, it's not that full court is the final seal. Judicial review power is always there, we keep on interfering. But where the possible view was there. In judiciary, you can't have just only the fence sitter.
Not
You need
actually.
performers.
The High Court judgment does not deal with record at all. The High Court judgment is only all general observation. Please see.
That's why we don't want that your compulsory retirement should be founded upon that complaint. We will clarify in the order.
Lord, the High Court has actually gone very far, my Lord. High Court says therefore in such circumstances opinion formed by the High Court on the administrative side cannot be interfered on the ground that it is formed without material.
That is absolutely
the satisfaction of the recommendation of the administrative committee, standing committee, full court cannot be interfered with unless tainted by patent illegality, breach of procedure, etc. But nothing is discussed, my Lord. This is all very general observations made. My record is not discussed. The point raised that this is not my report is not discussed.
You see, your record is there before the High Court when the view on administrative side is taken or view on judicial side is taken. Yes, sometimes
no complaint of integrity, nothing, Lord. It's at 53, his career is cut short. In fact, he only joined in 2000, and in 16 years, he has been asked to go.
He must not be regretting after returning to the profession.
Severely regretting, Lord. It's very difficult to first there are about 17, 18 of them. But anyway, I am only standing for him, Lord, because his record is the record of the officer whose case your Lordship rejected on that day is drastically different, Lord. And they have all been, just kindly pass on, they have all been considered alike. Just see the record of some of the others, Lord.
So others may have been having
the case which came up on that day. Just see that record, that column vigilance complaint. There are so many. I have just been taken up with them because of that one vigilance complaint.
Taken away, Mr. Purwalia. Now,
column number 4, vigilance complaint. Special judge has misinterpreted fact in the order. Then second vigilance complaint that one Mr. Pradeep Bhai working as superintendent and judge are in collusion, collect money from the accused person, settle cases. It goes on like this, my Lord.
That there also these were complaints only. There were no inquiry. They were not pending.
In this case, my Lord, I am only saying, my Lord, let it go for a reconsideration minus this report. High Court may High Court consider it afresh.
The problem is that it has sometimes very demoralizing effect on the administration of justice because the High Courts feel genuinely that the persons really don't deserve to be continued. And by now the vacancies have been filled up, the persons appointed, it becomes a difficult task. Yes, but the view to some extent, even if it is erroneous, we can clarify that part.
This is what I wanted to point out in this case, that so far as this officer is concerned.
So item 18.1, my lords, it's a completely different case, my lords. There is not even an inadequate remark in the SCR throughout. It at the most is a reasonable. May I request my lords to have 18.1, my lords?
So light now, please.
And then High Court says in the order that there are inadequate remarks.
Even if we have a good ground to substitute our view, still it doesn't.
Two submissions. But two submissions, my lords. In 18.1, in 18.1, there is in the ACRs, there is not even in remarks of inadequate. That's one. High Court says that there is an inadequate remarks. That one. And then second point, my lords, is that 4 years back, there had been 244 candidates who appeared for competitive examination, out of which 8 has been selected. I was the one who has been selected out amongst the 244, 4 years back, and promoted under the competitive examination of 25% quota 4 years back. Throughout the ACRs are good, or at least a reasonable one. At least one or two ACR are reasonable. Lordship may have that 18.1, my lords. And then there is no vigilance complaint.
First of all, you can't apply the general service jurisprudence principles in the judicial services. our yardstick, our parameters, our considerations must be of high pedestal.
But
Because
no vigilance.
this is one field where you have to perform and perform 24/7.
Lordship may just have my performance. At least peruse that performance. I'm not requesting anything more. Plus
Broadly, all
18.1, your Lordship may kindly have page 391, 392, my lords.
yes.
Lordships have annexure P13, volume 2, page 392 in 18.1. Plus, if your Lordship may peruse, it starts with reasonably good, good, average, then average.
Isn't good, nothing.
But that is, my lords, in 1994. But then after, throughout it is good. 1994, I was promoted and by way of competitive exam.
The criteria which Mr. Patwalia has just read out.
Yes.
That shows that for the purpose of getting an outstanding report,
Lordship.
you have to perform 300%.
Lords, I did, my lords, if just kindly
And it is
have.
not a criteria which was kept in sealed cover and suddenly the High Court has put some springing of surprise on you. It is not like that. All of you were aware that irrespective of the benchmark of 100, you have to perform 300 times, then only you will be graded as
My
outstanding.
remarks twice has been approved by the High Court. It says in that very report. It has been with the reasons that my representation was allowed and my average remark was set aside, was changed twice by the High Court. And thereafter, my lords, in 2011, out of 244 candidates, 8 were selected, passed. And then after 4 years, I have been made to compulsory retire. There is no vigilance inquiry.
Vigilance inquiry must not be there. With the vigilance inquiry, then it's a punitive action.
No, my lords, kindly have.
All natural justice has to be complied.
Complaint is that I have written 4 books. Now, these are the complaints against me. I have written books.
See, please appreciate those who have been inside the functioning of the system. They know well. Many a times we have, you can even brand them as hearsay complaints. But normally we call them spoken reputation. Now you don't get a document. You don't get any proof of anything indulging. But the spoken reputation sometimes becomes so bad that you are prompted to take a view. Because I have been very clear about it. The benefit of doubt must go to the institution, not the individuals. In the matter of
Something against me somewhere on records, at least an indication. That's the only request. There's some indication on record. Lordship may kindly have the High Court's reasoning.
Performance.
Page 30, High Court reasoning, my lords, kindly have. The High Court's at page 30, what reasons they give is that the petitioner has been assessed inadequate, poor. No, there is no inadequate or poor remark in entire ACR. These are all ballots because this entire judgment passed in one.
Let them enjoy.
One point of time.
Must be doing some arbitration also. Must be.
Nothing, it's now she is a lady, retired one. She can't even go to, she is not even practicing. She is not even practicing also. Is not doing anything. She is only.
No. In any
then
case,
this is stigmatic for her.
In terms of our order, in one of the cases, they are entitled to be considered for pension and other retirement benefits.
But now she is 61. She is not getting anything other than monetary benefits that she will be able to get. If at all your Lordship may consider to entertain this present petition. There's nothing further.
Whatever under the rule they are entitled to, we have clarified. We will clarify in this case also.
Not be forfeited. They will be entitled to pension. That they have been premature.
If they have a qualifying service,
yes.
Compulsory retirement, they will get pension.
Then stigmatic. This would be stigmatic, Malos.
No, not at all.
This is Malos in my High Court order. It says inadequate, poor. It is stigmatic.
That's a definition of your performance. That's got nothing to do with stigma.
From upholding the decision of the.
My lords, in that case, please request consider removing the stigma like my lords had done in the other.
Yes. Upholding the decision of the full court on administrative side, through which the petitioner judicial officers have been compulsory retired in public interest. We have heard. So, so and so learns in another counsels on behalf of the petitioners. Do the document you are referring?
My lords, this is the order.
They want that observation that it may not be treated as a stigma.
They have.
This paragraph.
Sure. On a general principle of law, the counsels have rightly argued that the High Court as well as this court possess power of judicial review, which also brings the administrative decision taken by the people of the High Court within their compass. Regardless of an opinion formed on administrative side, the High Court, in exercise of judicial power, is entitled to evaluate the decision-making process and can well interfere if it is found that the impugned decision is not based upon sound, valid, and lawfully known reasons. Next paragraph. Since the report of the High Court considered the cases of a batch of officers, it seems that the individual facts have not been, it is apparent from the impugned judgment that individual facts have not been dealt with in extenso. Consequently, an impression has gone as if some of the petitioners have been compulsory retired on account of specific complaints which were never inquired into, and where there is no finding of guilt based upon principles of natural justice. So in this regard, we wish to clarify. In this regard, after approval of the service reports, we wish to clarify that broadly, the full court of the High Court has been guided by the performance of the petitioners while forming the opinion as to whether they have become deadwood and are liable to be compulsorily retired in public interest. We find from the record that such a view could possibly be formed, especially in light of the benchmark guidelines prescribed by the High Court for evaluation of performance of the judicial officers. It is just clarified that each order of compulsory retirement passed in these cases is based upon overall performance of the officers and not referable to any specific unsubstantiated complaint stroke allegation. The orders of compulsory retirement of these cases are innocuous, not stigmatic, and merely in public interest. That's what we declare so. Next paragraph. Having done that, we follow our order is 13th February 2026, passed in SLP diary number 74408 of 2025. In the case of a similarly placed officer, and make it clear that the impugned orders of compulsory retirement shall not cause any impediment in the claim of the petitioners for post-retirement benefits. Order course. That's it.
Great.
What's in 19, your lordships would have noticed that there are two impugned orders. Now, I just want to take you to the second one, but before that, let me just mention what has happened. As far as the Mussoorie Dehradun Development Authority is concerned, in 2003, we had a concessionaire agreement for the interstate bus terminal. Now, that was constructed, 20 years passed, and after those 20 years were passed, we had some small claim, etc., for some adjustment. The 23, they gave it back to us. Now, suddenly we are finding that the other side, after operating this terminal for 20 years, has hammered us with a 400 crore claim in arbitration, which is why, your lordship can understand we are a little nervous. Now, the technical point which we have come with is relatable if your lordship has the synopsis before you, where we have set out the two statutory provisions at pages C and D. I'll state it. Under section 11 and under section 12, a written declaration has to be made before appointment, where it is a section 11 process, that the person has that the arbitrator who sought to be appointed is not connected either with the subject matter or with the parties. Now, that has not happened here at all. That's number one. Number two, they pass a general order, which your lordship will just have a look at. Please just go straight away to that. At page 106, annexure P6, which starts at 105. Paragraph 3. On 27th August 2023, during the process, in para 3 at page 106, the arbitral tribunal passes an order. The arbitrators on their part declare that they have neither any interest nor have they anything to do with the dispute in question, much less pecuniary or other interest whatsoever in the subject matter of dispute, so as to undermine the expected and required independence and impartiality. It is further declared that they have sufficient and ample time and ability to conduct and conclude the proceedings expeditiously. So our point, the first point is that there has to be an individual declaration in terms of the schedule, etc. by each one. You can't pass a procedural order in this manner. One. Two, the declaration is inadequate and short because it doesn't talk about the relationship to parties. It only says that we have nothing to do with the dispute. Three, and now here your lordship will find that there is an IA which we have filed because we discovered subsequently that one of the learned arbitrators wrote us individual letter to one of the parties, which is also not adequate, which we got to learn of later. That's in IA number 55750 of 2026, and it's at internal page 4 of that IA. Yeah. 90, 100. Huh?
So, yeah, never received. He considered say I was a leader. This is law. September
23.
Given to me now.
Yeah, that's right.
This is produced after.
That's right. Yeah. Yeah.
I think there will be an believe.
I'm sorry?
How you make out a case of violation of 12.3?
Yes. So can I just explain as to how 12? Because 12 requires a written. Please see minutes to your lordships have pages C and D.
Just clarify.
Yeah. Yes.
Chief Justice's question.
Yeah.
It's not 12.1 or 12.2. You must come within subsection 3 of section 12.
Yes.
To show that there is material that the fairness and the bias in respect of 5th and 7th schedule is disclosed.
Yes. So can I just answer
that? When the
so may I just answer that? The primary point, so I should just make it clear. My primary point is that 12.1A is not fulfilled because they are required to file a written declaration, and that is fatal to the process. It's at 2 stages. I'm sorry.
12.1, 12.2 can be substantially complied with. Procedural order takes care of it.
But that order also, as I read, doesn't say anything about
We
parties.
understand. Now, this is where we want to see whether it substantially infracts the equality of arms of the parties in this arbitration process.
Yeah.
Otherwise, we're not going to interfere. Because you have to make out a case. What you're making out is a breach of 11.8.
Yes, I'm making out a breach of, you're right.
11.8,
Yes.
breach of 12 subsection 1 or subsection
Yes,
2.
12.1A.
Our query to you is,
Yeah.
Percy, if there is a breach, the procedural order substantially deals with that situation.
Okay.
It may be to certain extent
Short.
in short or not up to the mark, but it takes care of it, and you are not concerned because after that you proceeded to file your statement of defense, amended statement of defense.
Yes, yes.
What is the case made out by you is an RTI reply with regard to 11.8.
I've seen that.
And now if you see the RTI
Yes, please go to the RTI reply.
It comes on 4/9/2025.
Yes.
And your application is made after the lapse of 15 days.
Yes.
So
that RTI
it is
reply was.
again it is not to be taken into consideration
Yes.
in view of 13.2.
Yes. Now,
13.2 says 15 days. You have not made the application within 15 days. And there, Mr. Diwan, we would have satisfied our conscience if on substance you made out a case that yes, this is an arbitrator who has been an arbitrator in an earlier.
Can I just, Manoj, I have come here on a I don't want to impute.
Technical thing after the much water has flown.
But just see the water that has flown. In 2020, if you see my IA, Manoj, please see my IA. Just look at my IA. In my IA, the other arbitrator, Manoj, your Lordship will see page 4 of the IA, annexure A1. He makes a statement to one of the parties and just says, it doesn't disclose it to both because your Lordship is asking me on the substance.
Yes.
Please just see. I'm a bit surprised when you sought my consent to be your nominee arbitrator. So this is to the respondent.
Yes.
In the previous 2 arbitration proceedings I conducted, to which the party is a party, in the first one, the High Court of Hyderabad nominated me as sole arbitrator in the instance of Haryana-based claimant party. In the second case, the company nominated someone else, and it is your opposite party company which has chosen me as the nominee arbitrator. Detailed awards were passed in both matters long back. That is the reason why I took time to think carefully about giving my consent. After going through the brief note, I realized that the present engagement does not have even a remote connection even with the 2 previous arbitrations conducted. Hence, I convey my consent to be nominated as an arbitrator on behalf of your company as requested by you. Please find enclosed.
Sir, this has a hiatus in the procedural order. That's why it is said there's nothing to connect with the present dispute.
Yeah.
And let the parties.
But this was not given to us. This was not even shown to us, my lord.
No.
Because, my lord, this is what is happening here.
Application for termination. And termination is 11.8. Termination case is 11.8.
Yes.
And in our understanding, 11.8 is substantially complied in the procedural order. And that is why the arbitrators also asked you to make out a case of breach of 5th or 7th schedule. No case was made up.
Very well, I'm grateful.
This situation. Thank you.
Item 20.
May it please your lordships. Urgent judicial attention is required, your lordships. My fundamental rights are at stake. Article 14, Article 19, Article 21, everything is at stake, your lordships. This is a case pertaining to getting my accounts freezed, your lordship, by 4 states, 8 districts, your
What about the victims' fundamental rights?
lordship. I'll clarify that also. 4 states, 8 districts.
Procedure established by law. If you are aggrieved, go to the criminal court or to the high court.
I'll tell you, lordships. I'll clarify that also. 4 states, 8 districts, your lordships. How can I go to all the 4 courts? Multiplicity of litigations, your lordship.
Victims are in 4 states. They lost their money in 4 states. Now you'll have to walk the hard way.
Lordship, what is
not
happening?
get the convenient route of Article 30.
At the end of the day, even I am also the victim of the circumstances, Your Lordship.
Everyone is a
Even
victim of
for a small suspicious transaction, Article 14, right to equality, has been violated, Your
You
Lordship.
were not only a mule account, you are continuing to be so in the litigation.
Lordships, but 4 states going there and finding one jurisdiction, there will be jurisdiction nightmare, Your Lordships.
No,
Because this deeply obliged.
Yes, item 21.
Your Lordships, learned senior counsel Mr. B. Sharma is appearing online.
May I please, Your Lordships? I am appearing for the petitioner who are the High Court employees. And one of the connected two SLPs are pending before Your Lordships. One from the Superintendent Judicial Officers. Well,
In fact, Lordships had passed that order asking the High Court to decide because we were in against the interim order. And then the matter was referred to the full bench, Lordship, and the full bench gave in our favor, state's favor.
So accept notice, we will examine it. Accept notice.
When the High Court employees will get less than the.
Find out some solution, but you can't have this kind of anomalous situation. High Court employees get lesser than the district courts.
There are 2 PILs, Lordship. No, actually, the district court part also, Lordship, that is per inquiry because I'm peculiarly in the state, Lordship, there are state rules. So far as the High Court is concerned, the rules are actually under 229(2). And
may I point out one thing, Marat, the 6 CPC pay structures have been given to the subordinate judicial employees.
I'll file my reply, Lordship. I'll file my reply.
Very unfortunate.
The 6 CPC recommendations have been implemented in respect of subordinate judicial officers. And payments have also been made with an undertaking. So we wanted to have it with an undertaking, if possible.
That's it. All right. Next item 22.
22. Please, Your Lordship. Your Lordship, this is a public interest litigation, Your Lordship, where we have challenged the provision section 16 of the Chief Election Commissioner and Other Election Commissioners Act 2023. Your Lordship, there is a blanket immunity in this clause, whereas just.
Why this kind of seasonal litigation start coming only when the elections are there?
Your Lordship, this is a very important issue, Your Lordship.
Every issue is very important.
Your Lordship, this immunity is not even available to President and Governor, Your Lordship, which has been given by this Act here in this Act of 2023.
Yes.
So, Your Lordship, may I just submit? Your Lordship, this is also important, Your Lordship. That
very vague and evasive, a complete wide and wide. There is no law pleading in this court, and nobody knows the basic tenets of how the petition is to be drafted. Absolutely absurd petitions are drafted. Very unfortunate kind of.
Your Lordship, only we have challenged one provision, Your Lordship. It's not that we are raising any.
Ask first of all your office of youngsters to learn what is the law of pleading. How to draft a writ petition.
Your Lordship, the only limited question is there. That's why very short petition.
All right, you want us to dismiss or you would like to withdraw and file at an appropriate. First go approach the authority, then come have follow.
I will withdraw this, Your Lordship.
Popularity slogan is not.
Oblige.
Counsel for the petition seeks and permitted to withdraw this petition with liberty to approve the concerned stakeholders.
No, my lord, there are 3 or 4 matters impugning the same order. I am in the first one. Lord, I will tell you, Lordship, the facts are somewhat interesting. So what has happened is this, we are in appeal against the order of that part of the division bench's order, which has set aside, my lord, the order of the single judge, Order 7, Rule 11. There are, my lord, a batch of cases. Therefore, I must tell you, Lordship, some basic facts. My lord, there was a 7-time member of parliament called Mahendra Prasad. My lord, he has passed away now. He had extensive, my lord, businesses and properties. One of the probably the richest MP, my lord, who has been in Delhi for some 50 years. So, my lord, he had a wife called Satula Devi. And he was living with a lady called Uma Devi. Both claim to be wives. Now, obviously, my lord, the dispute is about the estate. Estate is large. So, my lord, what has happened is the MP, my lord, made a registered will in 2011.
Probate suit pending, declaratory suit, probate suit pending.
Yeah, yeah. Blood, sorry. So the wife, my lord, files a suit after 50 years. The wife, my lord, cut it short, the wife has filed a suit. She's also dead now. She files a suit. Yes.
Also coming into picture, we do not know where it manufactured, who has tested them, where were they brought, and all these things. But these are all question of facts, essentially.
But I will therefore not tell your lordship any
The High
dispute.
Court has merely paved way for the determination of these issues. The real central issue will be in the probate.
That's a probate.
A probate matter.
So probate is going on.
Going on.
There's no dispute on that.
All other issues are also.
Lord, the law is, with great respect,
Yes, pay करके रखिए and order दीजिए.
my lord, your lordship, sorry, your lord. What I was saying, he's saying the same thing.
Yeah,
I told you.
Anything we'll have an easy way out. Let it be decided unenforced.
I know that of course, that of course. Oh, let there be a primary issue.
Exactly. 14. Order 14.
So, my lord, I will tell your lordship some 2-3 facts. I am not taking your lordship to any disputed fact. Yes.
The suit should be decided or taken up after the probate is decided.
That is one way.
But restoration of suit by the High Court is
Stay of suit.
But may I just
Better course which the High Court division may rightly observe is let the suit await the probate decision. Probate is an in rem decision. It should be taken. And let us say, Mr. Rohatgi, they are not able to prove the probate, have the probate on the will. Your suit would naturally revive and what you say as intestate succession and partition, everything will come to the fore.
no. So only one thing I want to say. Lord, I quite understand what your lordships are saying. I don't, my lord, have a quarrel really. Only one thing I want to say. So, my lord, the suit is fine. Also questioning the will. That, my lord, is not possible if a probate is pending. That is your lordship judgment. So now let's keep that aside. Now, my lord, for the other reliefs, as the Chief Justice put it, she says that I gave gold in 1971 to my husband, who was an MP. He was not a qualified engineer. And he used that gold to set up a vast empire today, which is of thousands of crores. And therefore, my lord, that law that I would be entitled to this, that, and the other because it was by Sridhar, etc. Now, what is important is the suit is filed 50 years after, my lord, this so-called 1971, when she gave the gold and the husband started living with another lady in 1974, etc. Now, what is important is this, my lord. She also filed a writ by saying that the husband was suffering from dementia. So she said, appoint me as a guardian ad litem kind of a situation because the Mental Health Act doesn't apply, this doesn't apply, etc. In that spirit, my lord, she has expressly stated that all the properties are of the husband and not, my lord, that she provided, my lord, the corpus by way of this gold, etc.
Properties in the sense that she is not disputing in the suit also. The properties actually were in the name of the husband.
But my lord,
now saying the source of generating these properties
Does it take 50 years, my lord, for somebody to realize a source?
But you see, the only difference is that suppose a complete stranger comes and jumps into a pending litigation saying, no, this entire empire is my creation. We will be the court will be very doubtful in accepting it. She is not a stranger. She is, after all, the first wife of the.
And she has filed a suit, my lord, against me. I am the wife of predeceased son of the plaintiff. I mean, look at what is, my lord, going on. I mean, she had 3 sons, my lord. I am one of them, one branch. The other 2 branches, my lord,
Other two disowned.
they were disinherited in the will. So the 2 sons and the mother gang up, my lord, against the predeceased son.
Because they are threatened by the influence of the other lady. The other lady's influence appears to be overwhelming.
So my lord, with respect, my lord, the 1 or 2 things I want to say.
The best way is let the probate proceed. In the meantime, let this suit be kept in abeyance.
Very well, my lord, if that is the lordship pleasure, because the judge dismissed the
In
suit.
the impugned order, my lord, they have already been consolidated. So it's before the same judge.
Consolidation is something different, but it must await.
At page
It must
71.
await because consolidation again creates a problem.
Given the liberty, there is one small issue in that, not only. There is one witness to be examined, who is the only witness who is alive today who can talk about this gold. So that witness examination should happen, not for which an order is.
No, I'm
So
sorry,
Lordship
but the
will say
suit
that-
must await,
that
otherwise the suit is hit.
Just see the last para.
One second.
Just see the last para 71.
Not the judge has mixed up the facts of the LPA of this.
No, the IA
He should have written a separate judgment, because all LPAs are mixed up. All
about the
suits are
court. If he dies, Lord, how will this suit be decided? That's the only problem.
Suit
I'm
has
not
to
saying
await.
suit should be decided before the probate. Suit will have to be decided after. But the proceedings should go on in the suit. That's all.
What do you mean proceedings should go on? You will
Because
have
there
the
is an
conflicting
important
evidence.
examination under order
No, I'm sorry, because that
1860.
can't be. You will then have conflicting positions in a suit and a probate. How can that be?
There is already a consolidation order at para 71.
That should be set aside.
Different jurisdictions.
They're completely different jurisdictions. One is in REM, one is in.
No, it's before the same judge now. Right together. Page 45, Lord, it is both are on the original side.
The original side is all right, but the jurisdictions are completely different.
And that your lordships also have said for
Consider that instead of word consolidation, the suit and the probate proceeding will be before the same judge. But
that's what has been done, my lord. Already done. Para 71. Just see para 71.
The lordships decide one after
No,
the other.
what is consolidate? So that can be
cannot.
Yeah.
The
Character is different.
The second thing, the suit will continue, the evidence, etc., can continue, but no.
Yes,
there
that
will
is
be no final decree.
no absolute.
Probate matter is decided.
That
will help.
But it will lead to conflict.
No, evidence will not conflict. Only evidence is to be recorded.
It is before the same judge.
It will rather help the party. Both sides will be benefited.
The division bench also was of the view that the suit can be stayed.
Yes.
It's recorded. So if the suit is stayed, it can't proceed with evidence. Your lordship will see that. They have not challenged that. Just see that part.
There are certain exceptions to that, Mr. Rocky. What Mr. Singh is pointing out is also very relevant.
Yes.
There may be a situation where a person is in poor health or a person may be leaving the country, etc. In these cases, there can be an evidence recorded subject to the maintainability.
That's
of
right.
Time be fixed.
Say,
Below para 70 records that
Yes, we've
contention.
seen that.
Yeah. And in any case, Milord, whenever the suit or whatever proceeds should be uninfluenced by this order.
So
Any other proceed, because this will have an impact.
say leave granted. We have heard Ransom counsels on behalf of the appellants as well as Ransom counsel representing the respondents, contesting respondents who are on caveat. Upon consideration of the matter in entirety, we affirm the view taken by the High Court so far as a restoration of the suit is concerned.
CSOS 203 of 20.
So for a restoration of civil suit OS 203/2022 is concerned. However, we deem it appropriate to modify para 70 and 71 of the influence judgment to the following limited extent. One,
Because we have said it can be stayed, we consider.
the probate proceedings and CS in bracket OS 203/2022 shall be entrusted to the same learned single judge as per the prerogative of Honorable Chief Justice of the High Court. While both the cases shall be preferably taken up for hearing simultaneously, there shall be no formal order of consolidating them. The same shall not be taken to have been consolidated.
It's the High Court has original side, so it can be taken up by the same High Court.
One after the another, but there shall be no consolidation of both the cases.
Shall be open to the plaintiff and accused to lead evidence in the event.
After 20 years.
The plaintiff in CSOS 203/2022 shall be at liberty to lead plaintiff's evidence. Especially if especially if the production of such evidence in near future is likely to become difficult.
Already application is there, Lord. Order 18 Rule 16. Application is already there.
All right. The plaintiff shall be at liberty to pursue the application under order
18 Rule 16.
CPC.
Subject to the maintainability
And the suit may proceed, final judgment should await the trial.
The plaintiff may proceed to bring the evidence on record in the suit. However, no final adjudication of any issue
in the suit
in the said suit shall take place till the probate proceedings are finally decided.
And if you not put expedite also.
Probate is expedited, it will bring an end to blood.
It will be in the interest of.
You get the probate disgrace.
It will be in the interest of justice for both sides. If the learned.
Any other proceeding, Your Lordship, because there are all kinds of proceedings.
That's expedite the proceedings in the probate as well as in the probate case. That is first to decide.
Yes. I also want that. There is no question. And that is what your lordships have done it in other cases also. That probate will be decided first, but both can continue.
Next probate. The civil will stand disposed of upon.
Much honors. And Lord, the suit number is 203 of 22.
Yes, that is correct.
Both suits, my lord. Both suits will be decided.
No, please don't. There is something, there is a hidden.
Uninfluenced, sir. There can be the pleadings in the declaratory suit would naturally overlap as a suspicious.
Judicial observation. They have been read against us in fact-finding proceedings.
Suspicious circumstances.
Those judgments are challenged and dismissed, and still they want something to be deeply obliged.
Item 24.
Fully uninfluenced by other proceedings in both.
And always.
That may be recorded, my lord, because all fact findings have been vindicated. That's the only limited request, my lord.
We are not influenced by anything.
Very well, my lord. I'm grateful, my lord. My lord, the testamentary case number 1 of 23 may be recorded in the order because only CSOS is reflecting. Just
if you can give the number of probate matter, we can mention that.
Yes, very well, my lord. I'll give.
Testamentary 1, yes.
Yes.
Item 24.
That's it.
Yeah.
May I plead, Lord?
Election challenge here.
There are 3 matters, Lord. All 3 are the same.
May I?
32 and 36, all 3 are the same. There are 3 SLP.
3 SLP, all.
Yes. May I plead, my lord, for petitions in this case?
You directly 32 and the.
Reason means, my lord, I have prepared the answer whole night, my lord. Then
very
after
well.
I am appealing, I have relevant answers, my lord.
Why don't you publish it in a month or so?
Why you prepare an answer when there is an appellate provision under Rule 49?
May I plead, my lord? Actually, my lord, I have approached Allahabad High Court thrice, despite
Is the Allahabad High Court the appellate authority? Who is the appellate authority? In an election petition, there is an appellate authority provided under your UP statute.
Yes, my lord.
Neither the High Court nor the Supreme Court is the appellate authority.
Yes, my lord. There is a writ jurisdiction provision. He may apply, my lord. But, my lord, in this case, my lord,
In face of appellate power, relief, we are not inclined.
I'll answer, my lord, these things. I'll answer this query.
Answer.
My lord, here ARO, assisting returning officers, my lord.
Don't answer on facts, answer on law.
My lord, reason
why the existence of an appellate remedy
Lordship
does not stand in the way of our entertaining an Article 32.
Lordship. Quick disposal, my lord, requiring.
Quick disposal. Then we should close down all our appellate courts.
Lordship, I am requesting only.
You are the only person suffering from quick disposal malaise.
Why, my lord? Reason being, my lord, for next elections, my lord, model code of conduct may be issued, my lord.
So what? Model code of conduct does not cover appellate bodies.
My lord, I was the winner. I got the 42 vote. Rival candidate get 41 vote, my lord. And despite being my declarations of winner, my lord, winner certificate issued to the Miss Suman respondent number 1, my lord. This is a categorical admission by the ARO, my lord. Kindly come to the page number, my lord. Just, I would like to. How?
No case to entertain a petition with is made out.
Lordship, may I request one thing?
So, well, may avail the statutory remedy of appeal in accordance with law.
Lordship, may I request one thing?
Thank you. Thank you very much.
If it is possible, my lord, kindly refer this matter to the High Courts, my lord. Otherwise, delay may be caused.
There is no special reason why you should bypass the law.
No, I am not bypassing, so I am just requesting kindly refer. It may be treated as a writ petition before the High Court.
First go and file appeal. Item 25.
Lordship, give me liberty to approach.
We have already granted.
Obliged. Lordship, may I request, my lord, kindly request the High Court to decide my.
High Court is not the appellate authority.
We
have sent you to the appellate authority. Go first file a statutory appeal. Otherwise, your writ petition will also be dismissed. Understand, please. Don't get emotionally charged with a brief. The lawyer has to act very dispassionately. Understand? Your matter, there is a statutory remedy available. There is a question of fact, whether you got 41, she got 42, or you got 42, or she got 41, whatever it is. So therefore, the appellate form is the more appropriate remedy with you, number one. Whosoever appellate form is there. If the High Court is the appellate form, please go to High Court. If there is any other form given, go to that form. File your appeal and don't go for advance booking in that you have not filed the appeal, we should pass a note in it.
I bow down my lord, but Lordship, kindly just take observation, may decide it within time bound manner. Nothing is otherwise expired. Tenure of election may be expired.
If you don't go there, our order.
I will go, my lord. I will go. I will undertake.
Our poor order will keep on waiting for you that you have never come to.
No, my lord.
Us.
I will file even within 2-3 days, my lord.
Very good. If you file and if your appeal is not heard, then you will again come. You have a very battery of lawyers. Look at how many lawyers. We are really fearful.
But my lord, time is the essence, my lord, in this case, my lord.
Yes, sir. Very good.
Otherwise, it may be expired within 4 weeks, my lord.
Very good. If they don't decide, then you will come again to us.
Lordship.
Item 25.
This will not done. This matter, my lords, in this matter, I am appearing in the fresh petition. And for the petition of the fresh.
Notice returnable is considered. just the notice. Remind on the next day, we will have to order some probe that to identify
Exactly.
the relation.
That's one of the prayers we have made, my lords.
Remind us on the next time
Yes.
when they are
In
appearing.
fact, my lords order of 4-25 in the other pending writ and 6-2, both of them take note of some of the issues. They have taken note of the issues. Very well.
But maybe meanwhile some problem is solved. So now sports tribunal is being likely to be constituted.
Maybe. Last time the
National Sports Tribunal.
what is the date of the order? January, no? January. Last occasion, my lords, in January, when that pending writ came, ASG seems to have made a statement. There's a report which can solve all the issues, etc. But I don't know what it is, my lords. We'll take out notice, my lords, and
Better we don't pass an order today because they will have some ready-made answers.
answer for all of that. Yes, I know,
This
my lord.
matter requires a deeper probe.
Exactly.
We have to think of that who should be the authorized.
Yes. Yes, just one request, my lords. Based on the interim order, this so-called body is going on. So a returnable date, my lords, within a specific. Yeah. Today, nothing matters about that. So this will come with the other matters, my lords, to be tagged with the other matters.
What is the date in the other matter?
What is the date in the other? 24th, I understand, my lords.
24th.
24th, it will come.
We have no difficult. 24th.
Very well. Deeply obliged.
Lordships, I may be accommodated for a week's time. I need to file some additional documents, Lordships. Only it has come yesterday, Your Lordship.
What are those additional documents by the way? What kind of fraudulent reputation?
Whenever I am going to the Karnataka, Lordship.
Where is the requirement of going to the Karnataka in this country?
That is
the only thing.
This is the same thing I wanted to. So
the judiciary proudly tell you that you can file case while sitting here, or you can file online, you can argue online.
Lordship. So my submission is, whenever, any time, any moment I am going to my constituency or the Karnataka state, so there is a FIR against me, Lordships. Every time there is a FIR. So they have admitted that there are 60 FIRs against me. Lordship, so I cannot go over there. And I am related to the party.
There is a necessity to go for you to Bangalore. Why don't you file a petition while sitting here to Bangalore?
Lordship, that is there. So that is there, Lordship. I may go there.
That is there.
Kindly see.
Below your status.
Lordship, no.
Remedy is there. You can go to High Court, but unfortunately nowadays going to High Court sometimes becomes below status.
No, Lordship. Not.
You are a defeated politician.
This perception may not be taken, Lordship.
You are a politician who lost election, and thereafter you feel your status as
no, I am
so high.
30 years old man. I have a ISI threats, Lordship. So every day I am being threatened.
When you can file petition in Supreme Court, what prevents you from filing an online petition in Karnataka High Court and argue while sitting in your office or in the chamber?
So, Lordship, that
give us one good reason.
That is one. So that kindly see the additional document which I wanted to place on.
We don't want to see anything. We are only on the preliminary issue. That why should we entertain a petition under 32? Every day when we are telling the others, why should you
be an expert? Why I wanted to show only 2 pages, Lordship. So additional
only because you have some political vendetta in Karnataka government, therefore we should entertain.
So, Lordship, they are not allowing me. So police is not with me. Lordship,
every day this kind of litigation coming.
Lordship, police is not with me. I put the name of the political leader, Lordship. So he is behind me whenever I am going there. So I am being manhandled.
You commit 307, 302, and police should be with you. You should be provided police protection. Very good.
Lordship, so without protection, there are 60 cases. How I am supposed to go there, Lordship? That's why I am before my Lord.
Sir, we cannot say, maybe that all false cases are there. Go and challenge before the High Court.
Kindly see the additional document which I have placed before your
Thank you very much. Thank you.
So page 22, your lordships.
Here, read page 67. What he is claiming is this only, that I am a political leader of so-and-so party and I am therefore in a position in Karnataka and therefore.
So, lordship, kindly see page 21, sir, the additional document.
We see no ground to entertain this petition under Article 52 of the Constitution. This is the petition, if so advised, may approve the High Court of Karnataka. So, even with respect to his submission that because of multiple cases, he cannot enter the state of Karnataka we do not find any merit in such contention. The petitioner can avail the facilities of online filing and arguments of virtual hearing.
So, liberty may be to approach the High Court that
We have granted, sir. We have granted. We are already afraid of you.
So, lordship, one submission there. If there are 60 FIRs, I have no idea. I have annexed only 26 FIRs, lordship. We have no idea how many FIRs are there.
Please file a petition in the High Court, first seeking this relief only, that the state police may be directed to give the details of all the FIRs to you. You can approach that. You are in a safe legal advice.
At least let's say some security.
Sorry. We know that this is the real purpose of this petition. You want to go there, you want to land up at the airport with an order of the Supreme Court as a badge on you.
No, lordship.
But now I have come.
No, I am a 30 years old man. I am the beginner in the politics. I am nobody. 30 years old man.
Please जाइए आप अपना जो remedy avail कीजिए. Thank you very much.
Like
27 letter 28.
28. Sanction भी है ये तो पैसा देकर पूरा
May I, my lords? My lords, the principal issue that we raise, my lords, for your lordship's consideration is that, my lords, on the basis of materials.
Principal and major issue is that how, even if there is a prima facie material against a corrupt officer, how difficult it is in this country to prosecute it. That is the principal.
My lords, with all the respect, my lords, I would humbly request, my lord, that the observation, my lords, I will take straight on my head, my lord. And I have an answer to that.
We will not mention a word.
Yes.
Go take all your plea before the trial court, please, with great difficulty. Maybe that because of the indirect or remote intervention of this court, the sanction has been accorded. Otherwise, who is going to touch these blue-eyed officers? All India services officers, who does them?
My lords, I understand, my lords, what is being observed, my lord. Allow me, my lords, this bit of a liberty to state upfront that, my lords, the sanction, my lords, which came to be declined on 4th August 2022 was, my lord, sorry, 2025, pardon me, my lords, was based, my lords, on the communications, the position, the assimilation of the entire content and context by none other than Principal Secretary for the state of Uttarakhand on a qualitative reply dated 16th June 2022 in response to a notice dated 19/4/2022 issued by Central Zoo Authority. Insofar as, my lords, whatever has happened, the government at the highest level, my lords, I am only, my lords, an Indian Forest Service officer of the, my lords, year of 2004. When the government, my lord, says that insofar as providing the sanction, providing the clearance, providing the budgetary finding,
prosecute these legal.
Yes, that you get.
There must be some district judge officer normally there.
So, my lords, in 4th August 2025, order of the sanctioning authority, my lords, what is taken into contemplation by the sanctioning authorities is primarily, my lords, the state reply, this 16 June 2022, which is a 25-page reply, covering all the issues, lock, stock, and barrel, and if I can use these words, my lord, on record. Secondly, my lords, is a state affidavit filed in detail, dated 19th of April 23. Then, my lords, the entire material sent by the federal authorities while, my lords, investigating the matter at the stage of supplementary investigation, and the legal advice, my lords, perceivably from, my lords, the legal department of Government of Uttarakhand.
We want to know that was he a judicial officer, because then we will propose something that why he should also go unescaped.
My lords, my lords, insofar as legal advice is taken into consideration, whether that legal advice, my lords, was from the government authorities, their legal department, at, my lords, the executive level or otherwise, can be best answered.
Department of Justice, there is a post of this legal advisor is LR and something, and in this state there have been some blue-eyed officials who have never been transferred for years and years, all politically well connected.
My lords, I understand with all the respect that, my lords, government would always, each and every state would have its legal department. That can be best clarified. But, my lords, my humble submission here.
Please don't invite any comments from us, better.
My lords, may I? Allow me, my lords. Insofar as, my lords, today, my lords, granting this subsequent sanction on the basis of the same material, without there being
incorrect legal advice was given. If a sanction is denied on incorrect legal advice, the earlier order is void and cannot be said to be a reappreciation of the same facts.
My lords, I bum. My lords,
there is no estoppel against law, sir.
That's correct.
Right?
Yes, my lord.
And if you see the subsequent sanction,
yes, my lord,
there is the CBI report which says
that's correct,
that you persuaded your officers to cut X number of trees and say that you make incorrect forged entries in the logbooks as teak trees, different teak trees. Now, that on the face of it is a case of forgery and cheating and abuse of your official position. Now, if on that fact, a legal advice had been given that no offense is committed, I do not know how you can argue even that there is a reappreciation on facts.
my lords, insofar as, my lords, the first decline, the sanction that is declined, my lord, and the subsequent sanction which is granted, my lord, the subsequent
Sir,
sanction
if
doesn't
you argue further, we would be persuaded to observe that this is a fit case to frame charges against you. Forget about sanction.
My lords, may just, my lords, allow me, my lords. My lords, the only thing which I, my lords, want to persuade is if your lordships, my lords, kindly have a look at page 161 for a minute, my lord.
Yeah, this legal advice purely extraneous consideration. And if he is judicial officer, then his conduct is also very, very serious issue to be examined. Tomorrow in default, he can become prestigious, he can be elevated also. One has to be very careful. We would like to examine it.
My lords, may I? My lords, whereas, my lords, I fully bow my head down to, my lords, what your lordships are, my lords, observing. May I, my lords, respond to lordships, my lords, observation? The legal advice, my lord, at this page 161 seems to be, my lords, very clearly in terms of the stand position of the government from the pen of, my lords, the principal chief secretary, insofar as the controversy is taken into consideration. That's why, my lord, that document is the soul of the entire thing. Now, my lords, examine this proposition and I'll leave it to my lord's lordship's discretion. I am only here to, my lords, see to it that, my lords, the client's case is put across. The principal secretary, my lords,
154.
yes. Now, my lords, insofar as my lords, may I also, my lords, your lordships pointed out, my lords, a very important issue on felling of trees beyond sanction. On that, my lords, state on an affidavit, my lords, at page 743 on your lordship's screen in para 9, state on an affidavit before, my lords, this very honorable court says, my lord, the following. Would your lordships kindly have, my lord, page, my lords, volume 2, page 745. May I read, my lord? I state and submit that question regarding grant refusal of sanction was examined by state government in detail. It was the bona fide view of the state government that case in hand may perhaps be a case in which departmental proceedings or major penalty may suffice and the investigation.
That is state subjective satisfaction. We don't agree.
Page 152.
When cases of forgery are disclosed and ecologically fragile tiger reserves are being raised by the person who is supposed to protect them, you feel departmental proceeding is sufficient?
My lords, may I say? Insofar as, my lords, those, my lords, observations are taken into consideration, the investigating authorities themselves have not found me culpable. My lords, when this inquiry.
That is what we saying, sir. Page 153, 154. The CBI report says on your instruction,
my lords,
the illegal felled trees are being covered up as bona fide felling of thick trees.
My lords, may I?
And that is where the culpability comes in. A superior police officer, a forest officer is passing off illegal felling as bona fide felling by making forged entries. How far can you abuse your official position, sir? If these facts are true.
My lords, may I respond, my lords, in response to page 152, my lords, without, my lords, going for a hair-splitting exercise.
We shouldn't, but then you're forcing us.
My lords, may I? My lords, what here the sanctioning authorities says, however, investigation has revealed that accused public servants during illegal constructions at Park Road Tiger Safari also unlawfully facilitated felling of significant. The identifying trees were also felled.
Paragraph 27 of the sanction.
Yes, my lord. Now, my lords, insofar as this is concerned, my lord, they, my lords, say that at the time, my lords, what they allege against me is that you were at a supervisory position, my lord.
Are you arguing against conviction?
No, my lords, may I, my lords, if your lordships are not then inclined, my lords.
Not at all. We should have understood it much earlier.
My lords, the only thing, my lords, what persuades us, my lords, the only thing what persuades us is that, my lords, the core of the prosecution is going to be that whether approvals were granted or not. And on that count, my lord,
for discharge.
My lords, then your lordships may, my lords, reposit with me the liberties, my lords, to take up these issues.
The liberty of framing charge against me.
My lords, may not, my lords, pardon me for that, my lord.
We may not, we will also may not give you that liberty of discharge.
Then, my lords, allow me to withdraw, my lords. Just give me the liberty to take it up, my lords, at an appropriate stage, my lord.
What appropriate stage? You're telling
before
there is no appropriate
stage. I can, my lords, take these, my lords, issues before the learned trial court, my lord, when it comes up. Insofar as, my lords.
This is the malady of the criminal administration in our country. Everything at appropriate stage and thereby dilation and postponing something most obvious.
Accept the sanction. My lords, I may be allowed to, my lords, withdraw then.
On this ground. What do you want now?
Lords, my lords, withdraw the petition, my lord.
After arguing the case, we said, I'm not seeing a counsel for the petition, section, to withdraw this.
I'm so grateful, my lord.
Yes, item 29.
Now in 29, just give me 2 minutes. Yeah, well, it's 2 minutes. My lords remembers that according to us, the matters we decide in legal trial as to whether it is performance or rendering, etc. Leaving that aside, in deference to what fell from your lords, and well, before I came to your lords, I have already acknowledged the tradition. Yes. Lordship remembers it's already acknowledged. In deference to what fell from my lords, I made a formulation which meets the ends of justice till the trial. Can't accept it, but only because what fell from my lords that you must acknowledge it. I'm putting it here, and the matter can go to trial. The impugned order will stand subject to this substitution. Subject to my lords, subject to my lords. Kindly hand it. Give it to them. Just the 2 lines. My lord recollects in the, even before I came to the court, I had acknowledged the language my lord wanted, they rendered it first. After Amir Khusro, they claimed they are the first renderers. So, wholly without prejudice, this is exactly what fell from my laws. I don't want my learned, because otherwise, they cannot have this and then again argue the matter. No. Composition inspired from so and so, first recorded by Julia. This is what fell from the Chief Justice also, apart from Justice Bakshi. And this takes care of the matter till the matter is decided. This will be exactly as the order stands with this substitution, subject to my lords seeing this. I'm not arguing the matter in light of this.
There's 2 aspects. If instead of Junior Dagar brothers, if the names of the 2 people can be included.
They want their specific names.
Name you can.
That can always be done.
Very well, let them not keep on asking, but I'm saying yes straight away. I'm saying yes straight away.
They are celebrated persons.
No, I'm not saying no, but only thing is let him not keep on adding. That's all.
No, he doesn't add.
This will come in a slide, there's some space, but we'll put it. We don't want to hide the names. That's not the object. Obliged.
Indo-classical music, sir, this is a part of respect to tradition.
Plus, your lordship knows both sides. Artists are very sensitive, and we understand that sensitivity. Artists by nature are
able to
very sensitive. But lordship will make it clear that lordship is not tinkering with the order except for the substitution. Because otherwise it will be said that my lord has altered the order, stayed the order, substitute this, that, and the other. By the way, one more thing before lordship dictates. I don't want to raise it now. My lords in good faith made an observation. I am in equally good faith responding to that. I have a collection of the press between the last date and today. I don't want to make a grievance. They are painting as if Mr. Rahman has lost badly. I have acknowledged plagiarism. I have acknowledged copying. I acknowledged him even before I came to court. My lord is changing the wording only. I've got this whole cutting. This is the way your lordship can't police what is reported. I understand that.
Sometimes it may not be in their hands also.
No, that's I'm just pointing out what happens.
The way the things sometimes go out of control.
So his client was telephone. Mr. Rahman said, "Have I done all this?" Which is reported. Anyway, so he's also sensitive.
If I may make one submission, I don't have a difficulty with this, provided that their names appear. But there are certain aspects to the challenge. For example, the order of the division bench says you can't look at private contracts. Whereas there's one contract they look at, the other they don't look at. There's also concerns about findings about originality. Now, if your lordships considers, whereas this interim arrangement may be gone into, but the challenge to principle should be left open for trial.
It's on trial. That's what. In trial, in any case, it is open.
Please.
It's always an interim injunction. Your lordship never binds in the trial.
But the clarity on
judgment
that,
says give the para.
There are serious observations.
Lordship need not say anything. Judgment says this is for purpose of interim injunction, not affect the trial. It already says so. Give the para.
So leave granted.
And just one last aspect, the deposit, I think they hadn't objected to, or they want to take the deposit back.
No, we are not taking it back to the trial. No. We are not taking it back. I said so in the beginning. If we win in the trial, we'll see. Not today, Manas.
The issue that has arisen for consideration in the civil appeal pertains to the grant of ad interim mention in civil suit commercial number 773 of 2023 titled Ustad Fayaz Wazifuddin Dagar versus A.R. Rahman and others, which is pending before a learned single judge of the Delhi.
The operative part is at page 75, para 141. That's the operative. The operative of the lordship is there. And it only needs to be substituted by
The learned single judge while considering the prayer for addendum restraint order issued the following directions. This is page 969, para 200. Next paragraph. In intra-court appeal, the division bench of the High Court has reversed the opposite decision. Opposite order observing as follows. This is
Page 74, sir.
Page
75.
of the land presiding judge. Sums up as follows. There are 3.4. 3.9 and 3.8. Next paragraph. On the previous date of hearing, the matter was heard at some length, also having regard to the fact that eminent musicians whose performance are probably acknowledged are in contest in the civil suit. We have persuaded the parties for an alternative and interim arrangement, regardless of the reasons assigned by the land single judge or the two judge bench. Upon persuasion, Respondent 1 has agreed that as an interim arrangement, on all OTT and online platforms, the slide depicting the credits in respect of the subject shown shall be as follows. Composition inspired from the Dagar Vani tradition Drupad, first recorded by
The name is late Ustad Fayuzuddin Dagar. That's at page 659.
first recorded by Ustad and Firazuddin Dagar and
Zahiruddin.
and nephew of late Ustad and Zahiruddin Dagar,
Lordship.
popularly known as.
Sorry, not everyone. The petitioner is the nephew.
Just
He
give-
is Ustad in Zahiruddin Dagar.
It has to come on the credit, so it has to be short also. It won't come otherwise. So as Shiv Stuti is the last two words.
Shiv Stuti by only.
Will remain as it is.
But it was
Just
by
the two names will come instead of the Dagar brothers. Just the two names.
Two names will come.
Two names. Because it has to fit
Instead
in.
of Junior Dagar brothers,
That's all. That's all. It
as
has to fit in otherwise. It won't fit.
By so and so, so and so. Which was first recorded as Shiv Stuti, as Shiv Stuti by so and so, so and so.
Whereas this is without prejudice.
The
Only without prejudice.
respondents have already deposited a sum of rupees 2 crores in terms of para 200 in bracket small b of the judgment of the order of the land single judge dated April 25, 2025. The said amount shall be kept with the registrar general of the High Court in the same manner as were directed by the land single judge. Next paragraph. Since we have not expressed any opinion, any prima facie opinion on merits, all the issues are left open for the parties
Very deeply.
to be agitated in this civil suit
without being without being
Next paragraph. It goes without saying that the civil suit shall proceed
Yes.
without being influenced by the observations made in one or the other order.
Well, it's one cent. I'm sorry.
Next paragraph. The orders of the land single judge as well as of the division bench stand modified to the extent above.
To the extent above is important. There are a lot of other.
To the extent above.
Yeah. Whereas one sentence is required, 4 weeks to make this modification on all the proposed credits. This for just Your Lordship say 4 weeks will be it will be done.
Respond number 1 shall
The Lordship's
modify and display the revised credits within 5 weeks.
Very well. 4 weeks, 5 weeks, whatever.
So Lordship
5 weeks, fine. 5 weeks.
So Lordship's keeping the questions of law available for
Yes,
decision.
all questions, sir. Question of law, question of fact, both are there in a civil suit. So both we have kept up.
The uninfluenced by the division bench and so on.
No, don't say uninfluenced. My learned friend, every time, that means Your Lordship is overruling the division bench. It's an injunction order. The para 41 of the division bench says that the trial will not be affected. My learned friend wants Your Lordship to add an sentence.
Thank you.
Obliged.
Yeah, appear for petition, Lord. This comes after notice sealing an order under section 11. I was the respondent in that. Lordship, my request is to please have a look at section 11(6)(a), because we as the respondents specifically said there were 3 separate agreements produced by them having 3 separate signatures of theirs. And as a result, we said that this is an issue that has to be decided at section 11(6)(a) stage. The section says that existence has to be decided at 11(6)(a). Unfortunately, the appointing court says this has to be decided by the arbitrator in the teeth of section 11(6)(a). Not the very existence of arbitration agreement, even prima facie, it has not been examined.
No, but that can be any preliminary issue.
Please have a look at, Lord, what are the two?
Lord, I must point out
case of
from the
forgery.
fact, Lord, that Your Lordship's interplay judgment is now very clear. Well, Lord, they should have pointed out in their SLP that 3 procedural orders had been passed by the learned arbitrator.
Yes.
It's not disclosed in the synopsis, my
It's
Lord.
an interim order.
Procedural orders had been passed. Twice they had sought extension to file, my Lord, their affidavit in opposition. And they didn't inform, my Lord. And after, my Lord, the section 17 order is passed, this matter comes up before Your Lordship, my Lord. And they don't inform Your Lordship about
Everything is disclosed in the SLP when the stay order was granted.
But you did not take it up as a preliminary issue before
No,
the
no, we are
arbitrator.
questioning it. Please have a look at the agreements.
No, sir.
No, please have a look.
High Court directed you and gave you liberty to take up this issue as a preliminary
that is what we are
point.
questioning.
You you acquiesce to the arbitration and interim orders passed, now you rake up.
After that, after the arbitrator is appointed and before we filed the SLP, the interim orders got passed without us filing the statement of defense. There were interim orders passed and we have specifically disclosed everything in the SLP. But please look at what has happened in the section 11.
Now, whether there was an agreement or not, with your forged document, all these are questions of fact.
Lord, but section 11, please have a look at the document. Lord, just have a look. 3 separate agreements they filed. One doesn't have their signatures. One has a different signature and one has a signature only on the last page. And one doesn't have signature on the last page also. Lord, please have a look at the document. I've just put all the 3 agreements.
You cross-examine them on this.
Yes.
Lord, please, that is the reason, my Lord, at section.
Why all pages were not signed, they will explain.
Lord, first document, they had no signatures of them. Please have a look at it.
It's a common practice when you keep the document, you don't sign it.
Despite direction, original is not produced. Lord, may I suggest this? Let them produce, sorry, Lord.
My friend wants a mini trial here, my lord.
No.
Page 10 versus page 10.
Lord, all
Lord, the
these questions
signature-
can be decided by the arbitral tribunal.
This has duty in 11.6a stage.
My lord's judgment, my lord, the constitution bench in interplay.
Lord, may I just show 2 pages, page 10 of the document bundle that I have given. The first section, the agreement that they produced before the section 9 court. Please have a look at my signatures here. No signatures by them, no date.
It's coming from them. Naturally, it's not signed.
Right.
You have signed
And then please see page 22. Please see page 22. My signatures, which was shown earlier, is not the same signature.
That is something which you have to place before the
And my Lord,
Your arbitrator is a former judge of this.
no, my Lord. On that, we are the last people to, Lord. That's true,
We are
Lord.
not saying at all anything. We are only saying that you should be confident enough that all these
100%,
issues will
Lord.
be threadbare exam.
On that, we can never ever have a question. But please see what, Lord, I will face a full trial before an arbitration of a termination agreement made by a United Spirit. Lord, it's a David and Goliath fight. I am a small person in Bihar. They are in Bangalore. And an arbitration clause having Calcutta jurisdiction, my Lord. They have nothing to do with Calcutta. My earlier agreement was for Bangalore.
Calcutta is closer to
No, my Lord, certainly. I would say let them come to Patna. We can handle it there. Lord, please consider this. Please have a look at page 7 and page 20.
They are not afraid of handle, they are afraid of mishandle.
Lord, please look at page 10. Let me put my point, Lord. Then Lordship may take a decision. Just let me put my point. Lord, please look at page 10. The first agreement that they produced had no signatures on mine. And please see the signatures of mine that are there. And then they were directed to produce the original. Original never comes. Then they produced page number 22. Same stamp paper. But please see my signatures. Lord, it doesn't require more than an eyesight to have a look at it.
What judge has said this can be decided.
Lord, that's true, Lord, but I am saying that at 11.6a stage,
You can't have a mini
Lord, it's
trial.
the duty at 11.6. It doesn't require a trial also, Lord. It's on the apparent on the face of it. They don't want this examination to happen because at 11.6a it says that the court will confine itself to the existence. Lord, existence is paramount. Only then the arbitrator's jurisdiction starts kicking in, Lord. And I can point out judgments, Lord. The recent judgment of Justice Narendra Sima says that this is the first step and only step that the 11.6a court has to do. And my Lord, 2 pages has to be seen here. One has my signature without the stamp on the left side. Other one, they say the same stamp paper. Lordship, please see page 22. Has the signature somewhere else and their signature only on the last page and not on the page thereafter. Please see page 23 doesn't even have their signature. Lord, it is so blatant that even in such cases, if 11.6a jurisdiction, otherwise everybody will come with any agreement. And
in fact, the agreement's been acted upon.
So, Lord, I would request at least even at a prima facie level, when it is apparent from a comparison of page 10 and 22.
Repeating.
Yes, Lord, I can only rephrase it in a different way.
Please don't.
And given the language of 11.6a, Lord, let this
taking the order.
Revolves around the alleged forgery stroke genuineness of the agreements containing the arbitration clause. In this regard, the High Court has already in the Indian Code held that the issue of genuineness or valid execution of the subject agreements can be taken up as a preliminary issue by the learned arbitrator.
Arbitrator has
Only directing them.
Which means the petitioner shall therefore be at liberty to raise all the contentions before the learned arbitrator. We request the learned arbitrator to consider such submissions preferably as a preliminary issue before proceeding on merits.
Lord, before proceeding on merits.
Yes, we said before proceeding.
Lord, even the original may be directed to be produced before the arbitrator. Otherwise, it
For the
will.
arbitrator.
Lord, I'll again make an application, and therefore, my Lord, if Lordship may direct it, it will only expedite the matter rather than us getting prolonged there, my Lord.
Please move an application. The
All those things can be, my Lord, they're submitted before the learned arbitrator, my Lord. We don't have to mean a trial.
We need not to pass any order.
Lord, your Lordship, would your Lordship say, my Lord, your Lordship have not expressed anything on the merits, my Lord?
Nothing has been expressed as it.
Go ahead.
All issues are left open. That will.
Lords have said all the issues are left open, my Lord.
All the issues are left open. All the contentions from both sides are left open.
Well, your Lordships will remember that on the 9th of February, your Lordships passed an order that scrutinizing of documents, well, is going to take some time. So therefore, time is extended till the 21st from the 14th. Whereas while this order was passed, on the 15th itself, they stopped the uploading of the documents. I show you, your Lordship. This is what is happening. They stopped the uploading of the documents.
Yes. Uploading of documents, what?
Those very documents which were allowed to be scrutinized, which your Lordship said within 1 week, allow them to be uploaded. Well, they stopped the uploading.
No, let us see which argument you are. Let us see your order, which part of the order are you talking?
Yes, at page 14.
Because every time very unfortunately.
No. I'm just showing your Lordship's order at page 14 of the IA.
Let us see which order are you referring to.
5339.
No. Let us first see the order passed by us.
That I'm showing that it's quoted here, Malad. 9th February, it's quoted here. That's why I'm saying page 14.
February.
Yes, Malad. Page 14 of the IA.
9th February.
Your yes, paragraph 19, Malad. Which is
paragraph 6 of
19 and para 6 of the order is quoted of 9th February. You said, be that as it may, to streamline the ongoing SIR process and address some of the apprehensions expressed by various stakeholders, while reiterating our directions issued on 19.1, we deem it appropriate to issue the following additional directions. Since the process of scrutinizing the documents submitted by the affected persons in response to notices served on them is likely to take longer than anticipated, and as suggested on behalf of some of the petitioners, we
let the state government ensure that all 8,505 groups.
No.
Paragraph 6, my lord.
6, Malas, page 14, Malas, the IA 54339.
Next page, page 7 of.
No. Let us read one by one, first of all. First, we would like to see what is the compliance on number 1. We don't want to rush into like this.
Yeah, fair, Malas, fair enough.
What happened to this group of the officers?
Yes, Malas. I'll read it. 9th February, in continuation of the order. Your Lordship wants to see para 6, or should I read the whole order? Para 6 is at 29, Malas. Yes, read that as it may.
6.1 is the first direction. Let the state government ensure that.
Yes, 6.1. Let the state government ensure that all 8,505 Group B officials whose lists are handed over to the court today report to the district electoral officers at 5 p.m. ECI shall have the discretion to replace the existing EROs and utilize the services of officers who have now been replaced on.
Now, just a minute. Did you find any eligible officer? Because last time you were questioning the eligibility part.
Beg your lordship.
Last time when we permitted replacement,
Yes.
questioning the eligibility.
Yes, that part
also.
has gone smooth.
Well, my lords have given us the liberty to replace officers. We have written to them, look, this is the requirement. We need officers of this nature, whatever the duties. And they have said in reply a couple of days ago, it is under consideration, you wait.
May I pass on the letter that they have written, Millets? Everything depends at this stage on adjudication about the documents and the validity. And that is required to be done by the EROs. We are short of qualified EROs because every day they issue one GO saying that one, based on a pay parity, everyone should be treated as if on a par, like SDO, etc. Kindly have a look at it this minutes.
Yes. May I, Malas, read that?
Yes.
Kindly see the last one, Millets, the third.
First direction.
The third one, Millets. My lords could see the third one. Regarding appointment of SDO, SDMs level officers as electoral registration officers and returning officers, and we have proposal received from CEO office. The state government is examining the matter of the list of eligible officers and will take up with office of the CEO West Bengal shortly. That is the GO they've issued.
17 February.
Millers, now kindly see the GOs they have issued.
This letter is on 17th February.
Could my lords have a look at these minutes? After that communication, 18th February, they issue this notification.
I'll give a copy of this letter to Mr. Sibbal, who is for the state.
I don't have it, Malas.
We have passed on.
Mr. Sibbal, if this is the communication by the state is responding,
Yes.
despite our order of 9th February, on 17th you are saying that you are still...
It's Group B officers, Malas. We have given Group B officers, Malas.
No, where are the SDO level? Because that is the requirement. Last time also it was discussed. Where the officers of rank of subdivisional officers or SDMs
Yes.
given. If you have given in list 8,000, fine.
Yes.
If they are there, it is fine.
Yes.
If you are not, if you had given, then you would have written that you have already given.
Yes,
Why?
yes.
Please read this clause 3.
Yes.
Regarding appointment of SDO, SDM level officer as ERO
Yes.
and returning officers, and in view of the proposal received from CEO office, the state government is examining the matter of the list of eligible officers. Eligible officers.
Yes. But we've given, Malas, 8,500 individuals, 108, 12 employees do not belong to
In that case, your reply should have been, we have already sent a list of 8,500. Please see, they are...
Group B, Malas, we've sent it earlier, Group B officers.
They know pretty well they are not qualified.
Officers is not the qualification.
For micro observers, yes, Malas. For micro observers, yes.
In West Bengal, SDM is a Group A officer.
No, it's for micro observers, Malas. Group B officers are allowed.
They are not observers, please. They are asking for this officer as ERO. We are not concerned about micro observers. We are only concerned about the RU state is not obligation to provide the officers in the rank of ERO.
Malas, you can answer that because I
have the...
Yes, you can answer.
Yeah, take the letter.
Yes. Group B officials is what we've got.
I mean, we are disappointed to see that this kind of both we were expecting the states will the election will cooperate.
Explain. May I just on behalf of the state explain, copies? May I just explain why in West Bengal?
No, why should we have private explanation? The state should explain.
No, I'm representing the state. May I just explain? Please
the
indulge
state,
me
madam.
for 2 minutes. Please see, my lords, in West Bengal, I've made a very simple chart for your lordships. In West Bengal, please see the top page, my lords. Now I'm just comparing it. I've chosen for comparison, say the state of Rajasthan. Every state has a different framework, my lords. Now please see on the right.
Quite possible. Maybe your state civil services can have a different composition.
My lords, we only have 69 SDOs. Say for instance, Rajasthan has 299. Now, why do we have 69 SDOs? Please see the next page.
In that case, Dr. Menka, what prevent the state to tell, look here, I don't have officers to spare for this responsibility. You bring from wherever you
My
want.
lords, when Mr. Sibbal says BDOs, please see what we mean by this. Because to become an SDO in the state of West Bengal,
So as
9 years, yes.
requirement is of a Group A officer of SDO and SDM.
These are Group A officers.
Please see the next place. It answers your question.
You see from your angle also.
My lord.
These officers are required to perform a kind of quasi-judicial responsibility.
Yes.
Therefore, an experienced, a partially judicially trained mind kind of is required. You can't ask a clerk by promoting him, a poor fellow, in a particular grade that now you pass a speaking order. They are obligated under the law to pass speaking order, to decide the fate of the people,
Yes.
to reject or accept their document.
Yes.
It's all a judicial exercise.
So please see page 2. This explains why we have done this. Please see. Because your lordship sees, my lords, page 2. I've explained page 1, where the framework in West Bengal is 69 SDOs. Now please see page 2, my lords. West Bengal, for instance. You are first posted as a BDO. After 5 years of service, you become a district magistrate or a district collector.
We don't want to, you have a system
That's
in your
it.
state. You continue with that.
Yes, yes.
It's not that you must follow Rajasthan pattern or Rajasthan should follow your pattern. To the extent you want to, whatever way you want to have your state civil services, you continue with that. We are not on that. Issue is that if you do not have sufficient Group A officers.
No, my lords.
My lords, my kindly similars, I have sent a circular at the notification by the government.
District magistrate, divisional officer.
They are Group A officers, Malas.
Millets,
They are
this Group A, Group B,
Yes,
Right answer.
yes,
Posted as block development officer.
yes,
After 5 years,
yes.
you post him as district magistrate.
Deputy magistrate, deputy magistrate.
Millets,
Deputy magistrate.
You are saying
80
district magistrate.
No,
What-
deputy magistrate.
After 2-3 years, then district magistrate, you post him as sub-divisional officer.
No. Deputy magistrate.
Your
Deputy magistrate.
Your document
My
is
lords,
It's a typo.
we have given the
Deputy
notification, my lords, my kindly see.
It's a deputy magistrate.
The
18th
officers
February.
provided-
don't have,
The
we can understand in some of the states, two things can always happen. One, you do not have sufficient officers available in a particular rank, which their statutory requirement.
Altogether.
Two, you have the officer, but you can't spare them. Might be that state itself.
No, my lords, if you're, if,
You could simply tell them that you please bring your own officer.
no, my lords, may I just?
We will
We have
deploy,
Group A
Millets.
officers which have been
Yes.
provided. We have Group A
Yes.
officers which have been
Millets.
provided, Malas.
5, the ECI.
These are Group A officers.
We will deploy necessarily trained officers
Millets,
from
this is
outside.
wrong.
We'll complete the
asked-
process
I
without
provide-
any hitch.
Your lordship
We have
may-
done across India in every state, including
We will
Tamil
file
Nadu,
an
Kerala and
affidavit
all other
that we have
states.
supplied to Group.
There has never been a problem,
Problem,
Millets.
Mr. Naidu, is your officers have little knowledge of Bengali. And that is the problem
Millets.
which is occurring.
Now, Millets, my lords have given micro observers. My lords have given micro observers, 2 sets of micro observers. They could as well assist.
My lords, please.
They could as well assist, Millets.
Please see.
Because it's a question of,
ECI's affidavit.
it's a question of passing speaking orders.
We have provided.
And Millets, what they say every time, if
Now,
we
what
press,
is- what-
they will say designated.
What is the bottleneck right now and what is the status of?
Millets, the
Because
bottleneck
it's
is-
quite a sensitive time.
There's a huge problem that we have. which-
Only one aspect, if your lordship permits, my lord.
We hope that the both sides understand the sensitivity of the issue. SIR has started.
Yes.
If you don't complete the SIR.
We will.
we go for election.
We want 48 hours to complete it, Malas.
May I just mention one thing? Micro observer.
Don't go for elections, what will be the next consequence?
No, Malas, let us not go there. No, nobody wants to change. Malas, may I just state the point? Your lordships acknowledged the primacy of the electoral registration officer in the last order. And Naidu very fairly said that as far as micro observers are concerned, those can't override or trump the electoral registration officer or the ERO. So that we thought was settled.
Correct view.
Now, just let me state the point. The point is that after your lordship's order, they have come up with a new species of officers called the special role observers. And those special role observers, even after the EROs are clearing the files, so these are files of people who are mapped. Once they are mapped, the expression which is used is that they review the files and they are parked. Parked means they are retained. Now what they've done is, they've got a new species called the special role observers. They've given login numbers to those special role observers and they override the electoral roll officer. So we have put in our, so that micro observer now is all right because they made a concession.
To their exercise.
Yeah.
That
Now, instead of quasi-judicial final statutorily recognized officer doing his job, after he does his job, after he clears it, they are now reviewing it and sending it back to him in lakhs. In lakhs, 7 lakhs, they are sending it back to him. So what is he supposed to do?
The things are very easy. They are taking, let us say, help of not one, multiple persons in identifying the.
Not after the ERO is cleared.
No. If the ERO and ERO has passed an order.
Yes.
Those will be separate matter.
Yes.
But the question is that if the ERO has passed an order and they have some doubt about a document.
Yes.
And they are asking him to look into that document.
Yeah.
What is the problem?
No, so can I just tell your lordships, after the ERO is the final call, my lords, under the statutory scheme, he makes the final call. So the micro observer was kept aside.
ERO can always say, look here, I have seen this document also.
Yes.
This document is either genuine or or unreliable.
What is done? That is what is done. Now that exercise is complete. Now what happens after that exercise is complete? They have given this, they have created a new cadre after your lordship's last order of 9th of February called special role observers. And we have put it, we have just hand it over.
Maybe my friend has
based
been
on
wrongly
record,
briefed, Millet. It's
they have
not
given
correct.
login numbers to
They've
these
been there from
individuals.
day one.
Just please
Show
have a
the
look
source.
as to our, no, keep the IA.
That's completely wrong.
Keep the IA. We have filed the IA. We have already filed the IA electronically. Just hand it over. Just have a look as to what's happening.
That whatever you are saying, they are saying that they are from the very beginning they are there.
Sorry?
They are saying that they are right from the very inception they are there.
Yes.
But the special role officer cannot trump the ERO once it's parked. The expression.
It has never been said, Millets, that they trump them.
Review it, they've parked
Millets.
it. Now just see three paragraphs of this particular application.
There are 30
just have a look at
EROs.
3 paragraphs. Please just go directly. Your lordship will follow the point over here immediately.
Create a situation where we have to ask the judicial officer now to intervene. I mean, kind of.
No, but how can they? How can you, on a wholesale basis, reject what the electoral registration officer or the ERO has done? Go directly to page 6, please. Please go directly to page 6. Now, first in para 10 at page, sorry. These three. I don't know. They don't know.
Just deficit.
Yeah, there is a trap
Two
there.
constitutional functionaries, the state and the election commission. of
Yes,
India.
yes.
And subject to what you will argue, we are only left with a very limited option. Either we will involve the state judiciary, will request the Chief Justice of the High Court to nominate some serving officers and to pick up some retired judicial officers of impeccable integrity. They will do, and both sides will assist them. Or the only alternative is to tell them to bring IS officers from other cadres who don't have local
May I
interest.
just make a suggestion? May I make a suggestion? I'll just explain the point. Your lordships, now as far as the paramountcy of the ERO, at least for
Both
the.
sides must understand that if you don't complete SIR, there are very
No,
serious.
we are not asking for time.
Millets,
We are not
millets,
asking
may
for
I
time.
submit millets?
Can't be that after the ERO has approved, after these map people are in, you then push back.
Millets,
and
it's
say,
only a red herring to divert the issue.
All right, Malaj, appoint judicial officer. I have no problems. Your lordship may decide it. Let's do it that way. But let's get, because Malaj, this has to be completed. We don't want time. Appoint a judicial officer. We have no problem.
No, one judicial officer can't do it.
No, whatever judicial. Let the Chief Justice nominate. We have no issues, Malaj. Ex-judges, whatever your lordship. We have no problems, Malaj.
Millets, my lords
Replacing
have
the
asked
role
at the
observers.
very beginning,
Replacing the role
what are
observers.
the grievances of Election Commission? Just kindly see, Millets, we have just listed out the complete non-cooperation and obstruction.
Their own affidavit.
And Millets, we could have been complaining about this vis-a-vis other states, never. All other states, they've been just going on an even keel.
But no other state have you done
Millets,
this.
yes, how about Tamil Nadu? How about Kerala?
Why so special
How
for
about
us?
any other state for that matter?
Where have you done the EROs in the observers
But
in other
see,
states?
Millets, the rate of rejection.
No, about Bihar, there is not a single complaint now, no case.
No, Millets.
Except one political party defeated in the election came before.
Yes,
us.
Millets.
That is over now. SIR near final.
The table, my lords, may kindly have a look at. The rate of rejection is very low in West Bengal.
No, my.
They're crying foul. When it comes to other states, it's 17%, 21%, 20%. The exclusions.
So what
Nobody
is the table?
complained because they could not prove.
What is this table?
Millets, this table, we have taken.
Document relying upon it.
My lords could see the first column, total electors
What is
before SIR.
7.1.
Yes, Millet. Total electors before SIR. Now, at the end of this exercise, what's been excluded tentatively, subject to the final list to be published. And Millets, the first one 20%, second one 18%, Tamil Nadu 15%, and when it comes to West Bengal Millets, it's 7.6%.
So why this so much hue and cry? We can't understand that.
No, why there will be
Yeah, you will read.
7.6%?
But in Bihar, it's
Why there
8.1
will be
and
7.6%?
Bihar is 8.
Millets, then my lords may come to the point
Yes.
4.
What's the difference, Mullah?
Bihar is also more than.
Kindly come to
Bihar
point
is
4.
8.3 and the West Bengal is 7.6. What's the
Millets.
difference?
No. Compare with those 20%.
But that's Andaman Nicobar, Mullah. Bihar is 8.31.
How
and-
about Tamil Nadu? Tamil Nadu
So
15.19 millets.
what? So
Kindly
what?
see millets. Tamil Nadu
They want to delete more names.
15.19%.
That's what they want, Mullah.
Gujarat is double. Gujarat is double than West Bengal.
Yeah, but what about Bihar?
Gujarat,
What about
Whisper,
Goa?
Malod.
Gujarat
What about Kerala? What about
14.5%.
Kerala? What
Millets.
about West?
We are not concerned.
Madhya Pradesh, 7.45.
Millets,
That is not.
it has fallen from your lordships an alternative
Let's
measure of
appoint
promoting
the
officers.
judicial officers.
If it appeals to your lordships, I may suggest.
Since
Yes.
the situation, as the Honorable Chief Justice indicates, there is a sense of hesitance at both ends with regard to the degree of cooperation and collaboration. We propose that if judicial officers can aid and assist the entire process and take it to a logical conclusion.
That's correct.
Yes, yes.
Yes.
Then on agreement, we can.
All to be done before 28th, Mullah. This must be done before 28th, Mullah.
That is what.
Because we want any time, Mullah.
And Miller, number two, up to 14th, that was the date was granted by your lordships. Up to 14th, whatever the documents have been submitted, that should be uploaded.
Millets, I'll answer that one. That's complete. Not a
Uploading
correct
has been
statement.
done on 13th of February.
We have got examples.
All those documents approved, disapproved, rejected,
No,
accepted. like-
Ultimately, an order has to be passed, Millets.
That's my application.
Being uploaded.
No.
Once they upload, they are scrutinized.
Mullah, there is another application, Mullah. Kindly have a look at page 30, your lordship's order. Page 30 of your lordship's order. Paragraph small Roman 6. So just have a look.
Which one?
Paragraph small 6, Mullahs, of your lordship's order, Mullahs.
That's it. Since the process of.
Yes, since the process of scrutinizing the documents submitted by the affected persons in response to notices served on them is likely to take longer than anticipated, and as suggested on behalf of some of the petitioners, we direct that at least 1 week beyond 14 to be granted to the EROs to complete the scrutiny of documents and take an appropriate decision. Now, Mullahs, on the 15th of February, they don't allow the uploading of the documents.
If the EROs are working like this, they are not qualified person. What option they have?
No, EROs are qualified. Nobody is saying that. They are not allowed to upload.
Officers of SDO Group A services. You are not providing the officers.
We have to
provide. Tomorrow, incompetent people decide fate of.
No, that's not the case, Mullahs. I think there's some.
Mullahs, it has
there is
fallen
no
from your
complaint on
lordship.
that score.
Judicial
Mullahs, what is
officers, let
happening
them
now?
take care
Just
of the
think,
whole
Mullahs,
issue.
we have given that document.
There can't be any
They have
grievance on
prevented the
on either
uploading.
side.
Mullahs, your lordship-
On either side, they can be.
Your lordship me. No,
It's
no,
only
there's
issue
nothing,
of
Mullahs.
competent officers, Mullahs.
Mullahs,
And they don't
we
answer.
are required to
They would like to
upload.
bring in everything else.
How can they prevent us from
Collateral issue.
uploading? How can they prevent us from uploading,
Mullahs,
Mullahs?
kindly let that issue be resolved. All else will fall in place.
No, what issue be resolved?
Up to 14th February, documents which have been submitted, that should be up.
General of Police. What happened to our direction number 7? To the Director General of Police and the Police Authority?
Filed, Mullahs, filed.
This is the letter.
It's filed, Mullahs.
4 FIRs. Registered.
Where is the state ministers? This week.
That's all filed.
My lords, we filed this, my lords.
Yes, filed.
We filed this.
My lords, may I
Affidavit of
kindly
the
see
DP.
Mullahs, allow me to complete.
provocative,
February, my
the
lords.
provocative, incendiary, threatening speeches issued across the state
Please see.
and have been
filed the
widely
affidavit
reported
responding
both on
to all these concerns.
visual and print media, no action taken.
Please see.
Some small fish, they say that I've registered a crime. Kindly see the threats, Mullahs.
We're not
Kindly
in the
see.
aquarium.
By the
Just stick to
responsible
the
people.
affidavit.
Kindly have a look
Stick
at the
to the
threat
affidavit.
perception we have been working
Mullahs,
on.
I haven't finished my.
Please see the affidavit that was filed, my lords. 18th of February, my lords.
Unfortunately, in this country, at the time of elections, all these irresponsible statements start coming very. You don't want.
All of their queries have been answered in the.
They are mainly concerned, is he ensuring that the law and order machinery?
Yes.
No, my lords. No, my lords.
Otherwise, the Director General of Police will have very serious consequences. We are warning the argument to.
There has been no incident, Mullahs.
First, not that we will approve.
I appear for the DGP. He has filed a comprehensive affidavit. This falls on a wrong statement from the EC. Every case has been investigated.
Mullahs, the proof
Put on affidavit.
lies in.
He's trying to prejudice by giving a lordship false facts. Mullahs.
Kindly see them, the statements. Let them disprove them. They're there in the public domain.
My affidavit first.
They're in the public domain. Have they taken any action against them?
Affidavit, Mullahs, of 15th February.
And those actions taken at our instance after repeated reminders and then your lordship's taking them to task. Not that they volunteered.
Why don't you exercise your power and direct the Superintendent of Police?
Indeed, my lords, we have been just diffident because matter has been seized up by your lordships. Otherwise, Constitution provides for that one. And my lords,
Very well.
during the
Let
once
us not talk of Mullahs, prejudicial words. Just
We will
turn to
do
the
that.
Affidavit of 18th of August. 18th
we
of
will do
February.
that.
Just turn to the affidavit. 18th of February, my affidavit. Just 4 or 5 paragraphs. Come to para 3.
Whenever a notification is issued, the police administration comes under EC. And the same thing, now we exercise, all these things could be avoided. Millets, Farm 7 have been torn.
First, let us now think of doing that, how this halted procedure is at least recommenced and properly.
Yes, my lords have said judicial officers, let it be.
Manoj, may I just
That
make
is a
suggestion?
very, very
My
equitable
suggestion,
suggestion.
If you just allow me to read 4 paragraphs of my application, where I was just on page 6, para 12, your lordship will understand the context and then you may pass an appropriate order. The problem which is being caused by the special role officers. Just have a look, my lord. This is, I think it's been handed over, IA 044626.
Mr. Dewan, judicial officers once communicated.
No, that's wonderful.
That's okay, Mother. That's okay.
I agree.
That will solve the problem.
Look at
Yes. Let them replace the special role observers. Yes, and the micro observers. That will take care of it.
That will take care of it. We have no problems.
Let the judicial officer take over.
Yes, my lords.
Maybe we leave to the, of course, we can't, we don't want to pass a blanket order like this. We will request the chief justice of the High. We have to respect his domain also. But we are quite sure that he will also understand our predicament.
If there are sufficient number of judicial officers who can be deputed on this task, nothing like it. And if there is any shortfall, my lords may kindly consider drafting in central service personnel, qualified personnel,
Very good,
working in West Bengal itself,
Yeah.
Search by any statute or.
of that rank.
There are 30 or between 30 and 35 special role observers. Around 30. Your lordship may, in substitution of that, assign.
Almost.
My lords, they filed an affidavit.
That has a reason for consideration in this.
My lord is dictating the order.
My lords may kindly see these special role observers. It's not something, on the first day they have been appointed, about 30 of them.
Saying anything.
Yes, my lords.
Saying the foremost urgent issue that has arisen for our consideration revolves around completion of SIR, ongoing SIR in the state of West Bengal. Various interim directions have been issued from time to time, including those contained in our last order dated 9th February 2026. Next paragraph. There is an unfortunate blame game from allegations and counter allegations, which clearly depict a case of trust deficit between two constitutional functionaries, namely a democratically elected state government and the Chief Election Commission and the Election Commission of India. The stage where the process is now stuck relates to adjudication of claims and objections of the persons who have been included in inverted commas logical discrepancy.
That is
Logical discrepancy. The most of the persons to whom notices under this category were issued have filed their, have submitted their documents for, in support of their claim for inclusion in the voter list. These objections are required to be adjudicated. These claims are required to be adjudicated from in a way through quasi-judicial process by the EROs, As per the in terms of the rules, practice, and convention, the EROs are the state government is obligated to provide Group A officers to perform the duties of EROs who are in the rank of, who are in the substantive rank of SDO stroke SDOs. No. People are. There is a serious dispute between the parties with respect to the substantive stroke actual rank and status of the officers who have been provided by the state government for performance of the duties as EROs and AEROs. Also, it is nearly impossible for this court to determine the prescribed status and rank of the officers or the officials now deployed by the state. Deployed with the state with the Election Commission of India by the state government. Be that as it may, in order to ensure fairness in the adjudication of the genuineness of the documents relied upon and consequential determination for inclusion or exclusion in the voter list, comma, and as agreed to by both sides, comma, we are left with hardly any other option but to request Honorable Chief Justice of High Court at Calcutta to spare some serving judicial officers along with some former judicial officers of impeccable integrity in the rank of additional or district judges, the rank of additional district judges or district judges. Who can then, in each district, be requested to dispose of the pending claims, to revisit, dispose of the claims under the category of logical discrepancy. Also, each such judicial officer, former judicial officer, shall be assisted by the, what is the name you have wrote?
Micro observers, my lords, my lords.
Shall be assisted by
No, no micro observers, Mullah. That's the whole point.
we have said assisted, will just wait, will be assisted by
Assistant.
Apart-
Quasi-judicial power cannot be entrenched upon.
micro and influential observers from the Election Commission of India side and the officers of the state government who have already been deputed by the state to perform or assist in such duties. When both sides will be there, not one side.
It's okay.
Also. The next paragraph.
They can also decide.
The circumstances being extraordinary, comma, the request for entrustment of the responsibility to the judicial officers, former judicial officers, is also of extraordinary nature. We are conscious of the fact that it may, for a few days, delay the pending court cases, for which pending court cases, it may have an impact on the pending court cases also. No delay, it may have some impact on the pending court cases also. Honorable Chief Justice, with the assistance of a committee of judges, Registrar General, and the principal district judges, may evolve some interim arrangement for shifting of matters of interim relief or urgent nature to the alternative courts for a week, 10 days, within which this entire process is required to be completed. Next paragraph. Since it goes without saying that every collector and every superintendent of police shall be obligated and is hereby directed to directly render assistance and provide all kind of logistic support to the presiding judicial officers and their team for the purpose of smooth completion of the pending process. For this purpose, the collector and the superintendent of police shall be deemed to be shall be under deemed deputation for the purpose of ensuring forthwith compliance of the directions that may be issued from time to time. Next question. Actually, not compliant with the deemed to be a breach of the direction or order that may pass by the judicial officer, former judicial officer shall be taken to be a direction issued by this court, shall be deemed to be a direction issued by this court, and the state administration, state government, district administration shall be obligated to comply with the same forthwith, to ensure the timely completion of the process. Next paragraph.
We have a scheme.
Since the modalities will have to be evolved at the High Court level,
He's saying the same thing.
we we direct the State Election Commissioner, Chief Secretary, DGP, State Election Commissioner, along with another one authorized senior officer of the Election Commission of India, Chief Secretary, Director General of Police of the state government, duly assisted by and in the presence of Learned Advocate General of the state and Additional Solicitor of India in Calcutta High Court, to hold a meeting with Honorable Chief Justice tomorrow itself, as per the convenience of the Chief Justice of the High Court. They shall put up the proposal, respective proposal as to how to remove the stalemate and complete the pending process. The mechanism to be evolved, the mechanism to be evolved shall be left to the entire discretion of Honorable Chief Justice of the High Court. Honorable Chief Justice of the High Court. Our only anxiety is that the work should commence and be completed smoothly without any hindrance as early as possible.
But before the 28th.
No, 28th.
Before 28th, fellows. Before 28th, that's the last day.
Maybe they can.
May I just suggest to that?
No.
My instruction is this.
We don't know. We don't want mullets.
By 28th.
May I suggest,
we have
because I have got instructions on that.
The courts also, please appreciate. Today 20th. 8 days are left.
Yes, correct. So
my suggestion is this. I've got instructions. Millet's 28th is the last date.
That's correct. So it's before that.
Publishing the final electoral roll.
No, but
we will be allowed. We may be allowed to go with that one.
If the volume of the work is so large, do you expect now we are not punishing our judicial officers?
No, Millet's not on that point. To that extent, whatever is completed by that date, that will be published. And then they can undertake the whole exercise. A supplementary list can be published so that the task becomes easier. Instead of getting all things stuck at one place, now 95% is over, 5% remains. So this 95% will publish by 28th.
No, you can't.
No.
In what manner that would prejudice Millets? I just don't understand, except saying
how can you do that? How can you say part I'll publish, part I'll not publish?
Whatever that has been finalized, by 28th we'll publish. Millets, my lords may kindly appreciate, until the last date of nominations, any voter can be added.
Added,
So a supplementary list will give.
no prejudice caused to anyone.
Precisely, Millets.
Keep on adding.
Just
No, this is
opposition for the sake of opposition.
This is not happening in West Bengal.
Millets.
Not a single Form 6 is being accepted now by the Election
Millets,
Commission.
these wild, unfounded allegations lead us nowhere.
Inclusion.
There should be a concrete example.
Not only Form 7, not a Form 6 is has been accepted by the Election Commission now.
The process to the extent it gets completed by 28th February 2026 may be published. However, that will not be taken as the final publication.
Precisely.
It is an ongoing process till it is completed.
Malaz, it will create a law and order situation. Malaz, it will create a law and order situation.
To the
What
extent
will
that's
happen
published up to that, that's fine.
in one
May I
district,
just add,
after names are published, there will be a law and order
ultimately the
situation.
election commission that has to take a decision. I may add, Millets.
And subsequently, the supplementary list can be added.
That's it. To the
But
extent
Malaz, there will be a law and order district-wise. If half of them are not there, Malaz, there will be a law and order situation. People should understand, Malaz, the orders.
There are only two way outs. Either we extend the date.
No, please don't. Please don't. We don't want.
Then that has
Millets. Today, hang our judicial officer that you sit there.
So, Millets, may I just make one request? Millets, please reiterate paragraph 6.5 of your order, Lordship's order on the 9th of February. Please see 6.5.
That's
6.5 says that it is made clear that the responsibility is assigned to or to be assigned to the micro observers of the state government officials shall be limited to assisting the EROs, AEROs in the decision-making process. And in other words, as rightly stated by Learned Counsel for ECI, the final decision will be taken by the EROs only. This may be reiterated, perhaps, because there should be no...
The judge will take...
Not allow these babus to sit over judicial officer. Now,
yes, exactly.
No, judicial officers will decide, Malaz.
They are the substitutes for EROs.
Malaz, just one request.
Let
request.
them not doubt even judicial officers.
Malaz, may I make one request, Malaz?
Mr. Diwan, a clerk promoted as in the...
No, these are Group A officers. These are Group A officers.
Not humiliate a judicial officer like this. There is no question.
Malaz, I have a small request. Malaz, there are two issues outstanding, Malaz, which your lordships have not considered. If your lordships don't mind, Malaz. Paragraph small 6, which is that your lordships extended the date for uploading from 14th to 21st. They stopped the uploading. Now, Malaz, many lakhs of 1.5 lakhs cannot be uploaded. And Malaz, 3.5 lakhs, no notice has been given. What will happen to that?
Whatever the grievance, Millets.
We are closing the matter, Mr. Sibal.
No, but then the judicial officer should decide this also, Malaz, that's all.
They will decide.
But your lordship may permit that, Malaz.
All
Millets,
your lordship may
my lords may kindly have only one thing.
Second, hold on.
Your
Let
lordships
the
have
order be
said
passed first.
that when it comes to logical discrepancy, Millets, it is a composite block of logical discrepancy and unmapped category. They go together. So that the adjudication must be vis-a-vis all those cases.
They are all mapped. There's no question of unmapped.
There are unmapped cases.
No, there are no unmapped cases.
45 lakh are there. Millets, if they have any case, they can
unmapped
place before the judicial officer and get the approval.
Mapped is all right, but unmapped can be done. And all other ancillary issues.
Yes, Millets.
That have been raised before us or that may arise during the process shall also be determined by the presiding officers to be nominated by Honorable Chief Justice of
Great.
Manoj, there is
The applicability of documents, including the applicability of documents.
They wanted to say on the dotted line what the judicial officer decide.
It's fine. That's good enough. That's good enough.
Now, we will take up this matter in the first week of March. Let us see what happens.
Manoj, there is one outstanding issue, Manoj, which I wish to point out.
Clarification that I seek. That is, your lordships have said they may revisit. Now, the revisit should not be of 7 crore. It has to be only of that 7 lakh where the documents have to be reviewed. That's what even their affidavit says.
Millets, we ourselves have said the list that's been completed we'll publish.
Yes.
Who is going back and revisiting the whole thing?
Mapped everybody.
Unless-
We don't want to reopen everything.
Millets, we
have
ourselves have submitted. Much of it has been completed.
They are also saying same.
Yes, much of it has been completed.
Please clarify that.
To the extent of about 45 lakhs is the contention.
Issues which are not on the table.
We are not muddling it. Last time they should have told you that we have special officers, observers that were appointed.
There are.
Tell you. They muddled
That's
it.
part of the regulation.
They muddle
That's a
it
part of
every time they
instruction.
muddle.
Because if they don't read their documents properly, I can't be blamed for that.
Please cooperate with the High Court.
Yes.
We provide them logistic support and assistance that the state will have to provide. As a statutory, as a constitutional authority under the statute, whatever responsibility you will guide them.
Yes.
and let them perform their duties. Please create that environment where they can dispose of these.
Cooperate, my lords.
With my lord's permission.
We are only, again,
Who will
we are-
cooperate?
please appreciate. the
We are talking about
seriousness of
judicial
the issue.
officers.
If the SIR for unforeseen reason, if you don't complete it, what will be the consequence?
No, we don't. It must be, my lord. We are with you on that. It must be
Whatever the
completed.
constitution provides,
We
that has
don't
to
want it
follow.
not to be completed.
My lords, there is one outstanding issue with your lordship's permission. Romans 7, my lords, of your lord's order. My lords, the affidavit filed by the police, my lords, 28 instances were pointed out of violence, my lords. All of none, not one, the veracity has been opposed, my lords. And my lords, for that we have moved an IA.
Only one submission.
My lords, that requires consideration.
We are informed that the state police has taken no action in respect of some specific instances brought into notice by the Election Commission of India or other complainants. So we therefore would like the Director General of Police to file a supplementary affidavit giving full details of the complaints received so far and the action taken thereupon.
The progress
That's
of the,
because this is only.
progress of the investigation.
We'll do that.
We are registering.
By the first week of March.
My
By the
lords, this is
returnable
not an
date, we'll do
exhaustive
that.
list. So, this is not an exhaustive list, my lords, although all the cases under the list have been verified. But, my lords,
The affidavit will also respond to the complaints which might be received meanwhile.
yes.
Fine.
List of
Only
all
one
the.
submission, my lord.
Directions of
Prior
what
to
may
28th, please, please.
alleviate our apprehension about back-end deletion.
My lord,
It was a very serious
my lord,
issue.
my lord, kindly one submission, my lord. Prior to 28th, whatever the decision will be taken by the judicial officers, that cases should come within the 28th. That is
My lord has said. My lord has said that.
Deeply obliged, deeply obliged.
Every aspect has been covered, my lords.
Great. Please try to resolve it.
Come with the effective decree. So let the new IA. What?
Right.
No, that's not.
Grateful.
You can't get a better order now. What else? The kind of. How difficult it is, brother.
Our Chief Justice will be really sorry.
Well, this is what happens when authorities don't collaborate with each other.
Well, that's why we have seen very simple word of trust deficit here. That we unfortunately
Not expected, but that's
Very sad.
the tension of working a constitution.
Exactly, and then your lordship don't know who to believe, who not to believe. This is the other problem.
one line.
That's a problem for a judge to have.
My brother has rightly said.
Yes, brother.
One line with these directions. These directions have been issued in extraordinary and peculiar circumstances, invoking our powers under Article 142.
in some other state also. So judicial
Otherwise,
office can be back.
will come that of mind judicial office.
Deeply obliged, deeply.
Thank you.
Sorry to have troubled your lordships.
Because having been that, because I'm admiring the patience and the hunger. I don't know. I was telling my colleague, we are feeling hungry. Anyway, because now this matter today at least is simpler because they've also filed an appeal.
We have filed an appeal as well. We are challenging the same order.
Not to press it, Lordship may have it anyhow. I can't say this.
But it's actually before the center, not before the arbitrator.
Now they've also.
I'm challenging the reference. Challenging the reference. I have no agreement with them. Item 37 is my challenge. I have no agreement with them. There is no arbitration agreement. They are relying on a relinquishment deed, which has already been decided on their application.
That the High Court has said would be decided by the
I'm challenging that. It can't be. If there is a determination by an arbitrator, can I keep going on and filing more and more section 11s?
Yes,
I'm avoiding an
same principle as Cox.
Have instruction regarding.
Date for filing of statement.
Today.
My lord, I am also paying for a stay.
All right, 37 issue notice for the next week, 33 along with that. And may have
Yes,
instruction.
my lords may have it after 2 weeks. I would join with.
All right, 2 weeks,
Senior.
but have instruction then, huh? Now,
Proceeding, my lord, remain.
But they should not praise for the SOC today. SOC filing is today. They should not.
It's the center.
You file SOD.
Yes, it's before the center, not before the arbitrator. What they are, their apprehension is before not before the arbitrator. Right now it is before the center, the pleading. Saying we close your right, my lord. That's why I'm saying it is today is the day. My lord may have say that they will not press on that at least for the present. Otherwise, lordship may either stay the impugn order, both of us. It's not before the same arbitrator. That is why I moved this application yesterday, my lord. My lord may say and the center in the accommodate.
If we have written this word, we'll let us see that center also.
My lords may also note.
Wants to be closed down, then we'll do that.
If we showed them the order.
If the center wants to be closed down, then we'll pass that order. What can we do?
My lords, it is in the.
Polite now, please. I will take a copy.
My lords, the interim relief my lords have granted. It may be clarified. It is in AC 25. One which I will. My lords may note the number. I'll just give the number. In the impugn order. Pursuant to the impugn order. I'll just give the number. It is there in your.
Item 15.
AC.
Lord, may I request if your lordship could take this matter next week, Monday or Friday?
AC 206.
Whichever date, any date, your lordship.